September 3rd special meeting. If you would all rise for the pledge of allegiance. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Kevin Scramlin.
Here.
Janelle Keller.
Here.
Teresa Bills.
Here.
Jim Christopher.
Here.
Keith Wiederhold.
Here. All right. Approval of agenda including additions. I think we do have an addition.
We do, so, as we do not have a quorum on this upcoming Monday's meeting, we are adding just a couple of fire items to the agenda. I do have a couple of extras if you want, so I believe, are you in position?
Yes.
It is for hiring 3 cadets and a fill-in. So, sorry, there's a purchase request, and then hiring 3 cadets, and the request to hire a David Moulton. So if we could add those 3 to the,
You want to put it after the last
Agenda.
public comment, though?
probably, I would just do it after Vesper.
Okay,
Yeah,
let's make it B.
yeah. It actually will be B, C, and D technically, because we'll have to motion for each of those. So, yes, I would motion that we approve the agenda with modifications for September 3rd, 2025.
Second it. All those in favor?
Aye.
Opposed? All right, we will open public comment. We all know why we're here tonight. You got 3 minutes. I ask that we do use good decorum. We are all neighbors. But at this time, if you would just state your name, we'd be glad to give each and everybody a chance to talk. So, whoever wants to go first. All right. Mr. O'Shea, go ahead.
Pat O'Shea, Lynn Sean. I just have a few questions, I guess. I don't know if it's, they can be answered or not. But the one thing that bothers me the most, I think, is that most of the people in the township are probably more aware of the chicken laws here than they are about what's happening with this whole Vesper. Why, as I think you stated, this is probably one of the most important things the board has and will have to adjudicate on. Why wasn't there a mailer sent out to every taxpayer on the rolls? This is too big to just put for hoping that people will or will not see it on Citizen, or on the Groveland website, which most people probably aren't aware of. This should have been handled a lot better if we wanted to get information out to the residents. This isn't fair, because this is not in any way enough people that know what's going on. Most of there will be a much bigger crowd here had people known. And you can't just do this by word of mouth. That's unfair. And whatever, I know you're allowed to have special meetings with 18 hours notice or whatever it is on your website. That's not enough. This is too big of a decision not to include every taxpayer in this township. So I guess it's not really a question more about then. But there are some questions I have, and that's a question for each and every one of you. What would the one deal breaker be for each one of you? I don't know which way you're going to vote tonight, we'll see. But what would have been a deal breaker for you first off? Just one thing that would be a deal breaker on this.
Give me a working definition of deal breaker. I don't understand.
Where
the
you wouldn't
question.
agree for this to happen in the township.
Say again, I'm sorry.
Where you wouldn't agree for this to happen in the township. Is there one thing that would stand out to you? Yes or no?
Yeah, for me, if it wasn't being jammed down your throat by the state, I wouldn't want to hear.
Okay, but if we were part of the 70+ other townships that were fighting this, you may or may not agree with it, you may or may not back it. Because there are 70+ townships in the state who are going against this. They must know something that we don't know.
I wouldn't agree with that.
Okay. Ma'am, what would is there something that would stand out to you that would make you not?
Support
Yes.
an energy storage system in general, or
And
this
no, in
lease?
this township.
Oh, I don't support it. I
Okay.
don't support them in our community.
Okay.
I don't support it being here, but I'm with Jim, it's being crammed down our throats. So with that being said, I think we have to look at all the options.
But was one of the options to fight it, like the other townships had?
Well, when you get into fighting it, a lot of that lawsuit is just based on wording in there. It's not so much that if that lawsuit is gonna stop 233, it's about wordings in the cities. It's not necessarily, I shouldn't say necessarily, well, you could probably answer on this.
Yeah.
It's not gonna stop it.
No, the litigation is, just as the supervisor said, identifies certain components of that legislation, which, in my opinion, will not overturn that legislation. If anything, it might modify a little bit here or there, but there's no guarantee that that would even happen. So
That
it
was
means
your
that,
opinion. With all due respect, was there a second opinion sought? Was there a second opinion sought?
To my knowledge, no. But when I say that, there's, what, 1,200 townships, 1,000 townships, and there's only 70 in it, so I think there was probably a lot of attorneys that had that opinion.
But we don't know if it goes, right? We can't all take the same, opinion that it maybe is
Sure.
or maybe won't. For you, is there something that you would have go against, always get,
I'm not in support of this coming to Groveland Township at all. I have to be careful what I say, because, I think that, it was really, unfair the way that all of this happened. And, I also agree that, I think that the previous supervisor said that we don't have to be a part of that lawsuit to benefit from the outcome of the lawsuit. And he did research and was told that, whoever goes in on this lawsuit, everyone will benefit from the outcome of this lawsuit. And so we basically we're hoping that the whole thing gets overturned. But, at this point, we have to, I suppose, work within the parameters of what they've given us. But in my personal opinion, and we'll talk about this tonight, Vesper has a location already chosen here in the township. And they're somewhere in the queue. And I'm not of the opinion that we should help them along any faster by allowing them to move on to something that we become the landlords of. And there are things in this lease that I think still need to be discussed. And I'm hoping that we'll bring those up this evening, during the discussion part. And so, I don't know, maybe I've answered your question, maybe I haven't, but.
I also don't support it. When I say that, I don't support the battery storage facility in our community. What we're here to talk about tonight is moving into a different location that we do have a say in. The other location, we have no say at all in that lease. We don't get to speak to the terms of it, we don't get to decide, we don't get to negotiate with them to put anything in it. They're doing that with a private owner. And if we were able to move it to this parcel, then we have some say in it. We have some control over what's agreed to in the terms.
I guess all pretty, apt responses, but none, I guess what I'm looking for is someone to say there's absolutely something that would make me not want this in my township, and have rather than going behind the whole, I guess, idea that we can't fight it, and that we're going to sit on the sidelines and not jump in and support the other townships, which I feel we should be. Because if everybody sits on the sidelines and just leaves it for a few people to do all the heavy lifting, then they are going to fall by the wayside also. More people that show support, the more inclination there is for more people to join, the more momentum that happens. That's how things get done. But as we're sitting on the sidelines and saying, oh, we'll benefit from it, I'm sorry, but that is pretty poor when you're looking at how much you're going to depreciate everybody's property value if something happens. God forbid it does, and I hope to God it doesn't. But if something does, who's going to pay for water supply for everybody? Who's going, even if the water supply isn't, I guess, contaminated, who's going to pay for everybody that has to stay in, stay out? Who's going to pay for all that? And are there contingencies? And how can you have all those contingencies? Because that's an awful lot of money. And if they're willing to spend that much money, something doesn't seem right.
Thanks for your comments, Beth.
All right?
Who's next? Yes, sir.
I'm Wayne Ponton on 7181 Perryville Road. I guess I agree with this gentleman, and I only found out about this meeting a couple days ago off Facebook. So where is this new location being proposed or voted on?
On Grange Hall Road, it's where the new fire station is, it's right across the street on the south side of Grange Hall Road.
Okay, because, again, I guess the same question is, things, if there's an issue with this location, I mean, the township fought Stablix years ago to keep them out. Now seem like we're back in the same boat with a situation that could potentially damage the water supply. And that was the whole reason for fighting Stablix. So, why are we doing more to fight that at this point? I guess, we've got, I live fairly close to that. We're already dealing with other issues in our area. This is the last thing we need is another, headache on this side of the township. It seems like we're trying to keep the township rural. It seems like for everybody that lives on this corner of the township. So I guess it's just a little frustrating, the fact of just hearing about it just a few days ago.
Thank you. Yes, sir.
Ed Irvin, I live at 1315 Pine Drive. My concern is, you hear about lithium batteries catching on fire. And, burning whole houses down with like an RC car lithium battery in the garage or something. Are we equipped? This thing's gonna be huge, correct? I don't know what the dimensions of it are, but if, God forbid, something happened like that, are we equipped to deal with not only extinguishing the fire, but the byproducts of the fire and the aftermath of the fire? My concern.
Thank you. Anybody else? Yes, sir.
My name is Tom Phillips. I have vacant land in the township, and I'm procrastinating on building because of this. First, it's my understanding that none of you are at fault. Lansing through this action. Is that correct?
That's
Yes.
correct.
Well, there are non-lithium sources that have been used elsewhere. Is Vesper willing to use a non-flammable source?
That would be something that's in the site plan down the road, to be honest with you. Anybody else? Oh, go ahead.
Janice Robb, East Holly Road. My feeling is, and I understand that the state of Michigan has clamped this down on townships, and we don't have a lot of wiggle room. And yet, as you had all of your meetings for the past year, you came up with a YO and ordinance that would improve on Michigan's standards, and also included some things that would help to protect us. My feeling is, I don't want it either. I know you guys don't want it. Nobody in this room wants it. And it is being crammed down our throats by the state of Michigan. So, we must choose the lesser of the evil spots, which unfortunately is we're going to now place on Grangeville Road, which is still not acceptable. But if this has to be, and you have to make a decision about that, and it comes to that, can we still preserve all of your work that you did for months on the YO, having some standards set by the township to help us have an improved status? And part of it is a piece that if Vesper Woodson goes bankrupt, if there's new technology and they just cut this out over there, you've got the land already contaminated, if for any other reason that they shut it down, I remember you discussed having in that YO, and I don't remember the exact term, not bonding, but some kind of a
Surety.
fund, what was it?
Surety.
Security.
Surety.
Surety, I'm sorry, I'm not a lawyer. But they also said, EJ, right here, they agreed that, yeah, there could be something like that, where we'd have a fund set up as we go, and as the cost of living goes up, it will increment up as the years go on to protect us for this devastating thing where the land would have to be decommissioned and reclaimed back to a suitable piece of land. And that's my feeling, is that in this new way we're going down the road, to maybe go with this other piece of land, that we still need the same securities, the same, et cetera, to protect our people and our spot and our township.
Thank you. Anybody else? Go ahead.
Don McCoy, East Holly Road, it's my backyard too. I feel if all the townships would have banded together, you know, you said approximately 1,200. If what would happen if we would have had 800, 900, or 1,000 townships that protested this, I think the state would have been more apt to listen to us. But with 10% of them, they're just walking all over us. And I agree with the first gentleman that talked. I talk to people all the time that, I talked to somebody a couple of days ago that lives in the township, had no idea any of this was going on. Didn't hear anything about it. I don't know, it ain't in the news. It's word of mouth and that's about it. But I wish they would go someplace where the people wanted them. I don't know who would want them, but that's where I wish they'd go. Someplace where people wanted them. I agree with you, I don't think anybody in this room wants it, but our hands are tied.
Thank you. Anybody else? Carrie?
So as the board knows, I did email the board today with my letter from 2024 in August. And I didn't, because I worked on that and I worked on some other things, I didn't get to write my thing out today. So I'm gonna go from notes and from my heart. I guess I just care a lot about this community. That's why I'm pushing. I care about the community, not just myself, not just my personal address, but I care about everybody in here and everybody else who's been represented here. I care about the Holly School District. And with all due respect, I'm finally glad to see EJ back in one of these meetings. To say that it's my understanding that the queue that's in the MISO for Vesper expires this month. So I feel like there's been a pushback on this board because last November we said it's tabled. It's tabled until that lawsuit that you're talking about gets resolved, because Will said out loud, public record, that if there is anything that happens with that, and it might take a while, then this township would benefit as well. And you did not advise that we join that lawsuit. So we were on hold until just all of a sudden, and then surprise, another special meeting, and here we are again about a week or 2 weeks ago, saying, oh, we're gonna move it over there. With all due respect, Kevin shook my hand last July. You said to me, Kevin, if you're voted in, this isn't coming here. And I'm putting it out there because your words gotta mean something these days. Because all the rest of the crap in government seems not to. And EJ, it's not personal, like you said, this is business. To my face, you said it's gonna be 250 to 350 million you make. Well, this 100,000 or 150,000 you're offering this board is a drop in the bucket. Being on the Holly Area Chamber of Commerce as an elite member is a drop in the bucket. You get a big kickback from the Holly Area Chamber of Commerce from your investment. Free dinner tickets and everything else. So I'm just saying, I think this is so much for you guys, a big decision, and I missed the beginning, I don't know if you're voting tonight or not. And Will, with due respect, I think you need a co-counsel who's been on this kind of stuff, because they got billions of dollars in their attorneys. And I don't know what your whole background is, and I'm not knocking you. But I'm just saying, if you guys decide to do this, and this becomes reality, you better all put the residents first, because the gentleman that says that he's thinking of not building, and there are others that are thinking of moving, and it will change the whole dynamic of this whole community if this thing comes. You'll have your corridor, but you will not have the community that exists today. Think about that, please.
Thank you.
I'd like to add, since you brought it up, same thing, I think you're cool, and I looked your background up, you're very experienced. But it's kind of like hiring a real estate attorney for a criminal case.
Exactly.
I'm not gonna do that. I'm trying to stay out of prison, I'm not gonna go to real estate. So,
And this is so new.
I feel like we need to have people that have a background in it, so that Will can at least get help too, instead of having to say, I'm not sure about that yet. And I don't know if you have those resources available, I hope that you do. But I think that would be helpful too.
Thank you. Anyone else? Yes, sir, go ahead.
Ed Mannion, I live on Grangeville Road also. Just have to say, I agree with what everyone's saying here, but I think we need to fight this more, just like Pat and others have said here, so, just, we wouldn't have a country if we didn't fight, and, here we are trying to save our community, so just, that's all I have to say.
Thank you. Go
Yeah,
ahead in the
one
background.
little PS comment
Oh, go ahead.
is they're donating to the fire department, to schools, et cetera, the Chamber of Commerce, whatever. And if we don't have this protection that I mentioned earlier, that you all agreed and discussed, that the cost that it will cost our community to do all the decommissioning, et cetera, is gonna negate any money that they give us now.
Especially if they leak, even if they don't catch on fire.
Mr. Smith, go ahead.
I'm Greg Smith on East Holly Road. You've got two choices. For green energy, you can cut down trees, and clear some land, and put in your batteries. Or you can go over to the quarry and, according to the WIS 002 State of Michigan website, that is the Marshall Formation and the most productive bedrock aquifer in Michigan. So that's where you're looking at, the most productive aquifer in Michigan. We're all on wells. And I personally don't want Holly water.
No, thank you for them.
Thank you. Anybody else? All right, we'll close public comment. So let's discuss Vesper. Will, I'm gonna kick it over to you. You wanna go through some of the changes that were made since the last meeting?
Sure. Well, so, again, we're dealing with the option agreement between the township and Vesper, and as a part of the option agreement is the ground lease. And since the last meeting, we've spent a lot of time on the community benefits agreement, which is now a part of this ground lease. So if during the 5-year option period, that if this is passed, Vesper would have to elect to build at this location. They've got up to 5 years to make that decision. During that time, they decide to do so, then they would start to implement all the activity necessary to get licensed and get their equipment in place. Once they get the operational authorization to power up, at that point, the community benefits agreement payments would start. And so for the next 40 years, the township would receive on the anniversary of that date $250,000. So that was a big thing, and so that is now integrated unequivocally and unambiguously into this agreement. So that's that. We also spent some time on the issues of the security for in the event of Woodson going out of business and what would happen for the cleanup and the security, and so we spend time on that. There's a provision for the removal, security, and restoration, and there's thresholds for them funding basically the bond that would accommodate the cost of removing the units if they just decided to go out of business and walk away, which truly would probably never ever happen, because at that point there's lenders involved and the state's involved, and so that utter calamity of an operation just is practically not going to happen. But if it does, there's provisions in this lease that would, on an ongoing basis, provided the township an opportunity to monitor what they've got banked for cleaning it up if necessary. And we spent a lot of time on that with the Vesper lawyer reviewing that, and I'm satisfied that language is good for the township. Other than that, there was a lot of technical cleanups on indemnification and other protections for the township during the duration of the lease term that we made some changes on, negotiated. They were pretty cooperative in accommodating what they could. Any line in the sand was really caused by their lenders and what banks require for certain leases like this, because what happens is they package these up and they sell them on the market, and investors invest into energy projects like this, and so you can't modify the language too much, because then it upsets the language of the investors, and they won't allow a particular lease to get packaged with others and sold on the market. So, we pushed back as much as we could to get the provisions that were as advantageous to the township as we could make it, and I'm satisfied we got to that limit. Other than that, I didn't receive really any questions from the board over the last several weeks, so what the discussions that I had with the township attorney were more technical and legal in the lease, and so I'm satisfied that the product that is currently before the board today represents the best language that I think we can obtain. Understanding that no one wants this here, and that the litigation, I'll just detour for a second, the litigation that is pending dealing with Act 223 is just that. It's a lawsuit that is brought by, I think, maybe one law firm, maybe a couple that have some townships joining in it, and are challenging some of the nuances of the act. It's not going to necessarily do anything to the act. Your legislature, the people that you elected, they're the ones that could modify, rescind, revoke Act 233. And we may have a different set of elected officials in Lansing pretty soon. They're the ones that, if we're going to have any relief from 233, they're the ones that are going to make that change, not the courts. The Court of Claims is dealing with this lawsuit, and they wanted over $10,000 just for us to participate. It would have been a waste of money. So we are going to get the benefits. If anything happens from the lawsuit, we'll benefit like every other township, but we won't have to pay any money for it. But the action, if there's going to be any relief from 233, that's from your legislatures. So, contact your elected officials if you really want to push back on 233. So, in the meantime, we're stuck with that law because it's a state law, and the board's going to make a decision on the best route to take, recognizing the provisions that are mandated across the state of Michigan for the benefit of companies like Vesper to come in and source these solar or wind or battery energy facilities, because our government has decided that those are activities that we need as a culture. Right around, go to bed. And here we are.
I have a question. Since this, let's say we do get new people in the office, right? And all of this garbage goes away. So you're kind of signing this under duress then, forced by a law that we are forced to look at. So if these slime balls come back in 5 years and that law changes, then can't we say, we had to sign this under duress? Like,
That's a
can we
really
fight
good-
that and keep them out?
That's a really good point, and that's, you know, that's an argument. Would it be successful? I don't think so. I mean, this is a contract, you're reaching a contract with, an entity that has, a statutory right to pursue what they're trying to do here, and the WIO, the Workable Incompatible Ordinance, that we did spend a lot of time on at the other location. Some of that language might be transferable to the new location, but much won't, because a lot of it dealt with setbacks. Well, setbacks at the proposed location are very, very different from the setbacks at the other location. So some of the provisions we negotiated might remain and others won't. So we're gonna really be starting over for the WIO, for if the board does decide if this is the proper location. And if the board decides it isn't, then they're gonna go back to the other, the property they still have an option on, because they still have some time left on that option, and they're gonna build there.
Can I ask a question? Liz Chris, Groveland Road. I recall in the last meeting that there was a question on the agreement that it is in standing place with the owner of Bedrock, and has that agreement been terminated?
It's a really good point, and.
That's just my first question, but go ahead.
Okay, well, I don't want to interrupt you.
My second question was, and I'm sorry, now I've gotten distracted. There was also a question that I had raised about the current lease that Vesper has on the Holly area, the current location. If there was a clause added to this revised lease to get that property so that they can't ever build on it again. It was like,
Oh, well,
I think you wrote that down on your tablet to look into that.
okay. I don't wanna, are you done?
Yeah, I'm done now. Those two things are my
So, taking
main-
the second one first,
Okay.
so that's, you're talking about the option that they have in the other location.
Yes.
And so, what they decide to do with that option, if this doesn't work out at the alternate location on Grange Hall, then they'll go back to the other location and they'll pursue their rights that they've already created with that option for
Correct.
that lease.
But the new lease, if they agree to the new location,
Okay,
then with the new lease, is there a clause that they cannot go back and ever use the original lease?
well, we really have no, right to get into that because that's a contract that they reach with a private landowner.
So you researched that question and that can't be added to the current lease, the new lease?
Well, honestly, I didn't look into that because what this lease really has nothing to do with the other lease, and.
Well, it
and
kinda
it's
does.
a-
Yes, it does.
Well,
They
but
are.
as a
It
practical matter,
absolutely
they're not
does.
gonna
It
build
does.
two separate,
But if they've got the
projects.
ability to do that, without putting that clause in the new lease that they can't do that,
well, okay.
then that is an issue.
In this current one.
I think that's a big issue.
Okay,
Because
well,
Jessica said if things change, an investor comes in and invests this money to somehow put more power on the lines, I don't know even how that works.
well, they would, you know, if they're gonna pursue a second project in the township, right? You know, whether we can contractually force them to not do that, I can't imagine, and EJ could talk to this better than I could, but, I can't imagine that they would agree
Well, they're
to.
sitting sweet then, they got two leases in our township.
Exactly.
Well,
You're just gonna open the door for somebody else by letting them in anyway. Just like in the phone.
well, you know, they can, well, so, you're right, I have not talked to them about that and putting that provision in here, so that's.
It
that
should
is
be a major concern for the people of this township. Major.
What was your first?
Did you want to-
Elizabeth Christ on Groveland
No, no,
Road.
what was your first, question,
If
that I
the
cut you
agreement,
off?
the current agreements with Bedrock have been.
Oh, yeah, the mining. So, that one, they know about that. And, that is a topic that, it remains a big unknown, because Bedrock Express has, through 2035.
So how can this new lease be?
It's a great question. Bedrock Express has a contract with the township to mine, that entire property, and so they're gonna have to make, a deal, an arrangement with Vesper, that if it doesn't work for Vesper, then.
So how can we sign a new lease with them then?
We're not signing a lease, we're signing an option, and that option may or may not be exercised, and it won't be exercised if Bedrock Express tells Vesper, no, I'm gonna mine that entire property. So, in that case, if Mr. Bass digs his feet in and is gonna mine it out, then they will not exercise their option, and,
Do we know when is he required to make that decision now?
well, if the option if this current location, in this option and lease are approved, they have 5 years to work that out. And that's another reason now that I'm thinking about it, that they won't agree, Vesper will never agree to negotiate out their lease in the other location while the Bedrock Express opportunity is still hanging out there. So they're smart enough to not do that. So, but as the whole board knows, that is an unknown that could absolutely blow up this opportunity for Vesper. Mr. Bass says, I'm gonna mine it through, until I'm satisfied I got every value added coming out of that property, then he's got that right to do that.
Is that what, sorry.
Well, I'd like to comment, if I may, please. So I did spend some time, and I had a pretty lengthy conversation with Barry Bass recently, last week, because it seems to me that we have a pre-existing agreement with Barry Bass on that property, which, again, I will say is the Marshall Formation. That is hydrogeologically one of the best, longest, cleanest, largest aquifers in the state. And our Senator Ruth Johnson called me personally and said, please keep in mind, this is what this lease is actually proposed to move this site onto, is this aquifer. And on the south portion of the street, on the south portion of Grange Hall Road, this backs up right to Levy's pit that's already mined out, and the lake is showing. It's an open aquifer, like there it is, right there. So that is a concern to me, but I was concerned about Barry's agreement, because we have this agreement with him, and we brought this up a month ago, and we know this, that there was to be a meeting with Barry. Barry was supposed to be given some plans or something from Vesper about what they wanted it to look like and how, and I asked Barry, I'm like, how long is this agreement that we have with you? It goes until 2035. Barry has been paying this township for years, whether he mines or doesn't mine. He makes monthly payments to this township, they're royalty payments. He's basically making payments to secure his spot so that he can mine this when he gets to mine it. Now, we don't have a street going in because of some permit issues. He told me that he thought he had 5 to 7 years to mine this out. I asked him, are you okay with me saying this publicly? He said, Teresa, it's in the lease. The lease gives me till 2035 to mine this property. And I feel that that is our primary responsibility, is to honor that agreement. We can't have an agreement with Barry and then have an agreement with Vesper and say, oh, by the way, Vesper, you work it out with Barry. That just is To me, that does not make sense. Does not make sense to have, no, we either cancel the agreement with Barry and make the agreement with Vesper, or we honor the agreement with Barry and we say, this cannot happen. It cannot happen because we cannot have two different leases on the same land. That's what I'd like to share.
Justin, you wanna comment on this, cause you and I have talked, Barry.
Sure, so Mr. Bass is aware of this new proposed site. Obviously, he's in active operation, very active north of this site, and he's aware, and Vesper's also spoken with him to say, okay, we'd shift his timeline to mine the site. There is already some topography, it's been mined before is my understanding, and worked prior to this new lease, and so there's already some grade issues and so forth. So he would shift his operations and his timeline to mine out the property on the south, and then, which then, again, given that current grade, would hopefully, you know, actually help deliver the site to a better condition for this new option, you know, for the battery storage facility. So he is aware of it. It is, you know, the facts is laid out, the lease is till 2035, that he has blanketed across all the parcels, that he has this public information across all the parcels that he has control over per the royalty agreement as well.
Bob DePaul, Groveland Road. I'm curious because I saw an article in the Citizen a couple of weeks ago, and I thought it was Vesper is making an application for a site in Atlas. Not? Okay. That answered one question for me. I was just curious because it sounded like the same thing. The issue I think on this is Barry's not going to walk away from roughly, I think, $1 million we owe him in sand material. What I'm opposed to is the township taking an asset it has and artificially renting it at a substandard rate on the grounds that it's not reclaiming when we have reclamation entitled to us under the mining contract. When that's done, that was intended to be very valuable commercial frontage on Grange Hall Road. We should not be leasing it and saying, well, it's scab property that isn't reclaimed, even though we know we can get it reclaimed for free from Barry, and it will be very valuable, and then lease it for 40 years at a substandard rate. The township should not be subsidizing the rental cost for Vesper on this. We should not be taking an asset of the township and making it worth less in order to facilitate this deal so that Vesper can get it done. If they want to do that, and Barry's got to take his material out first and reclaim the property, then rent it to him at what it's worth when it's reclaimed. That's fair, because then we're getting our full value for it. That's my biggest objection to what I think is going on here, but possibly renting him the property at this unreclaimed rate. We are entitled to the reclamation. Barry knows that. Part of what he's going to do, and he's got about 5 million tons of sand sitting there on top of that aquifer, which, as Teresa pointed out, we're not setting on top of the aquifer. If you go to the south end of the property, the water that's setting down there is the exposed end of the aquifer. So if you pull 5 million tons, of porous sand out of there, now you can see that the exposure that I think Ruth was talking about was substantially higher on this site. And it's only 37 acres, so I would agree. Nobody wants this, including me, and I never did, okay? But the law is there, and the question becomes, where's the best place to put it? And I'm finding a hard case to justify moving it to 37 acres and reducing all the setback requirements to make it easier for people to find other places to put it on a piece of property that is going to have 5 million tons of sand pulled out of it, or somehow the township's going to have to pony up $1 million we owe Barry, which I don't think we're going to do that, and I don't think we should, and end up with a much more porous site than we have in the past. Everybody talks about contamination percolating through the ground to it, but you need to understand, if you just go on that 37 acres, the roll of the property will take you, the lowest point on the entire 37 acres is the back of the 37 acres, the south end, and it is a lake. And that lake is not above the aquifer, that is the exposed aquifer. So I don't want to see us take out 5 million tons of sand, put this thing in there, and then find out if something happens, we've got almost no barrier between it. And I certainly mostly don't want to see us lease it at unreclaimed property values when we know we can get it reclaimed for free. That's in the contract I did with them. And he's got an obligation, and Barry knows that, and he's fully aware of it. So we should be getting the money for that property based on what it's going to be when it's reclaimed. If he's gotta reclaim it first to get them on it.
Thank you.
Keith, did you have anything?
I share the same concerns as everybody here, but until now, we haven't had a say in this. Not that we have a say in it now, but this is something that we do have a say in, is this, the terms on this piece of property. And the reality of it is, I've done days of research on this, and the bottom line is we can play nice, or they can go to the state, and then the state will grant it. And then we get nothing.
But we had plenty of terms and conditions when we did the YO. We spent months listening to what the people were worried about, and months writing in ordinance that gave us the right to say, if you do it on that site, you will do it the way Groveland Township wants it, and they agreed.
But it's in my
As long as they agree. PA 233 says if we are not compatible with PA 233, then they don't have to go through us.
And that was the case at the beginning, and they agreed to do it when we wrote that ordinance out. We didn't put it through because of the pending litigation, and then everybody probably knows in the House, our state rep, Dave Martin, did a great job in getting a bill introduced to undo 233, which hasn't gone anywhere. But if you watch the Sunday morning news channels, you'll see that in Lansing, there are currently 19 Democratic state senators and 18 Republicans with one vacancy, which Whitmire has to fulfill that position within the next couple of months. And the gist of the program I was watching is that it's probably gonna go to Republican, which will give her a split house in the Senate. And now maybe we have a chance at doing something.
She just announced, I think it's next September is the election.
I thought it was May.
Oh, it's-
February and May.
oh, really?
Yeah.
I thought it was later than that.
Yeah, it can't go that long. She's procrastinating.
Oh, I know
She
she is.
thinks she's gonna lose it, which would fend for us to have a chance at maybe getting somebody that can do it. Listen, I don't want it, I don't like it's here, but I think it's unfair to say that we didn't have the ability to make any terms and conditions on that other site. We made plenty of them over the months. On every issue we could find that somebody was concerned about, we made the requirements for that site significantly stronger, and Vista said, okay, we'll do it. Which was a good faith gesture we're trying to get, and that's on 66 acres. This one's 37. If you write a while for it, you're gonna now be opening it up to other pieces, potentially of smaller property. We did that deliberately to try and make it big so it would be hard for others to be able to get it.
Oh, God, yes.
Yes, sir.
I'm getting a little mixed up.
Yes.
Are you referring to across from the new fire station?
That's the piece that, let's call that Site B, the one they're talking about today.
But is that the one you were talking about?
No, the original one was in the far
I
south.
know the original one. Are there 3 sites?
No, there's 2. And the original YO, the custom ordinance, was on the original site, but we never approved it. We got it all ready, but it never got approved. And
I
then,
was showing up last year at the meetings, I just got mixed up. How many acres is across from the fire station?
37.
We're also talking about a residential neighborhood versus a gravel pit. Big difference.
Go ahead.
I would like to clarify, I don't think that anybody in the room, especially on the board, wants this, in case I came across that I thought maybe you guys did, there may be only 2 people in the room that do. But my question is, why is the decision having to be made tonight? Why? It
doesn't have to be made tonight.
Okay.
That's my opinion. Like, I could make a motion right now that we table this.
Second.
That was my motion, that we table this.
I would support that. But I do think that additional discussion.
Yes,
should
there's
occur.
plenty more that we probably need to discuss,
Go
but,
ahead, Teresa.
well, I think the whole idea of, honoring the agreement we have with Barry Bass is probably one of my biggest concerns. And I do know that it's still uncertain. I understand he's got some flexibility, but he has an agreement that goes out to 2035. And he has a proven track record of making all his payments and doing exactly what he says he's going to do for this township. What is Vesper's track record? And why, like this lease, there's some language in here under number 11 permitting that says that we basically would help them get their permits and everything else. I don't want to help them. I want nothing to do with assisting them getting their permits, because it says we will, you know, where's the wording here? Owners shall use best efforts to promptly cooperate with grantee in good faith in grantee's efforts to effectuate the permitting of the portion of the property that will be the property finally leased for construction, development, and project operations, including but not limited to execution and return of any required documentation to the grantee, and so on and so forth. So, I don't feel like it's my responsibility to help them get their permits. That is their responsibility. And I read that in here and I was like, no, it's like, I don't know, this whole thing feels wrong and it feels rushed and it feels pressured and the people who live right near the township property, do they even know that we're thinking about moving this to their backyards? Are they here? Is there anybody here that, okay.
I knew, several others didn't until today.
Until today? Okay, so, like, I'm sorry you're late to the party, because the party started last year, and everybody that came in late to the party has to start on page 1 and get all caught up, and it is a grieving process, right? And I'm sorry, I'm so sorry that you have to go through this now at the same time.
Is there a map that shows the size of the area?
There's a map, like I can show it to you on a map, like just right outside there. But basically the original location and the new location are literally like a mile apart. The new location is maybe a mile north of the old location. Why are we not selling them the land? Why are we wanting to be the landlords? Why are we leasing it? And the only thing I can come up with is because we have an already standing agreement with another person. We can't sell them this land. I don't want to be the landowner when this project is left abandoned and then this township, all of us, are responsible for cleaning it up and taking care of it. If it's on somebody else's, I'm sorry, Mr. Sanford LLC, whoever you are, that you've got this agreement already with Vesper, and that's their private property, and that's not township-owned property, but we had a while that we could have passed, but we chose to wait because of the lawsuit, and that lawsuit is still not, I mean, I was on the phone today with Judy Allen from the MTA, who was saying that the challenge is still in the courts. There's a possible hearing in either September or October that the courts could be scheduling. MTA legal counsel says that the Court of Appeals likes to make a decision within a year, so it could be made by November. And she says, you know, I'm not sure how that appeal is going to go, but if it goes in the favor of the townships, then she has some thoughts that she did not wish to share with me today, but I understand that. But just another thing that she shared is that the MTA has been asked to be working on part of a work group for PILT, which is called Payment in Lieu of Taxes, PILT. That the battery energy storage facilities and all that, they don't want to pay personal property taxes in the future. They'd rather make a payment in lieu of taxes. So all of this supposed, you know, big money that's supposed to be coming, it's a shell game, and I don't really, I feel like if we enter into an agreement with them, number one, we're muddying the waters with Barry, we're complicating a lease that is, we don't need to do this, because we have an agreement with a upstanding local citizen who has been very good to this township, and we have an agreement that we need to honor until 2035. If Vesper wanted to say, we'll start our lease in 2035, that would be a whole nother story, but that's not what it's about. And I personally don't feel like it's the right thing to do, to mix the two and carry on business with one entity while we're trying to honor the business we're carrying on with another.
So I'm just confused, I just need to understand. You're saying, oh, Barry's good with this, he's gonna move up his operation, he's gonna whatever. You're saying, I talked to Barry, and you're not sharing the same information, you have a different concern that he didn't, like Barry didn't tell you, like, I'll move up my mining, I'll whatever, I'll do this.
Barry said that he would need some estimates of what's there, he can't say how long it would take, but that he does have a lease that takes him till 2035. It's possible he could mine it faster, and because I asked her, I said, so does this mean that you will be paying those payments until 2035? And he says, well, until I either run out of stuff to mine or until 2035, right? And at that point, if the township wanted to extend, we could, you know, or whatever, but basically he's been making payments for, I don't know how many years. Bob, do you know when it started?
It's about 25.
Yeah, I tried to dig through some files and found stuff that went all the way back to 2002. So I'm kind of guessing it's been close to 25 years probably.
I
And
think I did the first one when Tom and I went to court on that against Tri-City. I think that was like 98 or
It
something.
was late 90s.
Yeah, and then I think Barry was the one who won the bid about two, it's around 2001 or two.
okay, so he's been making these payments and, I mean, maybe he can mine it out in 3 years or whatever the thing is, but, you know, I've read through this, and Janelle and I, we've talked about this, you know, Vesper, we wanted Vesper to be Vesper Energy Development, whatever. And now there's a new Vesper Energy Finance LLC that the lease is with. And then another, you know, on the option, it's with Vesper Energy Finance LLC, and on the lease, it's with Woodson Energy LLC. So we wanted Vesper, the big parent company, to be the ones responsible, liable, but they're still not, and that's the wording that's on the leases, you know, on the option and on the lease, and that doesn't make me comfortable or confident.
What's their assets?
The Woodson?
Yeah.
I don't, zero, and Vesper Energy Finance LLC, I don't know how long they've been in business, but Janelle, you found something about something that they were.
I was gonna ask them about it, yeah. When I was just trying to do, and I'm a reader, I'm a researcher, I don't know who wants to answer this, I have a lot of sticky tabs, so don't take it offensively, but, I did come across that this Vesper Finance, so Vesper Energy Finance, that your legal entity identifier is not up to date and has been lapsed by almost 2 years. Do you know anything about that?
No, I have nothing to do with any of that, no, I don't know.
Okay.
I can find out for you.
If you could, I just think that that's really important that the board knows, because sometimes that's because of non-compliance, sometimes it's just an oversight that somebody didn't submit paperwork. But I think that's really important for us to know that, you know, what are we getting into and is there an issue already?
I can have Alan, our lawyer, talk to Will.
That would be
Give him the answer.
wonderful, thank you, I appreciate that. So that was what Teresa was referencing, is that I had just kind of discovered that in some of my research.
Is Barry mining that site right now, or is he just waiting?
We're waiting for permits.
There's no road
For
to
the-
get in.
For the road to get in.
Okay, so that's just set.
Yeah.
He's been paying all this time.
Mm-hmm,
Yep.
23 years paying.
Janelle, go ahead.
So I just had some general questions, and truthfully, Jim, I know you and Kevin have been in on some of these conversations. Will, I'm sure you have some of this, but I do think it's important, kind of just as a whole, we all know, we've said it over and over, this is a really, really big decision, no matter where it goes, if it comes at all. But in looking at this lease, I did notice that this updated version has removed the terms battery and renewable almost in its entirety. And now it is just an energy storage. It just seems a little bit like we are not necessarily even committing to battery, we're not sure what we're committing to. So are you familiar with that?
You're gonna have to ask Will about that one because they would have changed, like Will handled all the language changes.
Yeah, as far as I'm concerned, my understanding is that, it's the battery energy storage system. I mean, it's the same product, it's the same facility, it's the same use, lithium ion. I mean, if they're calling it this energy storage, I don't think that indicates that there's any different use contemplated that I'm aware of.
I didn't know, I mean, I know there is a solar,
I know it's
they
not
have a
solar,
huge solar background.
Yeah.
So I just didn't know if there was a solar storage. I am not a.
Storage is compatible with any form of energy production, so it wouldn't matter if it's solar, gas, or anything.
So this could be any type of storage potentially in this.
Well, no, it's just storage. It's just a battery storage. I don't know why they would have dropped the B, but there's no other form of technology other than like what we've been explaining and everything like that. So there's no like gotcha where we can drop in a new form of something or anything. It doesn't exist.
Well, I didn't necessarily think it was a gotcha, but I do think that in a lease, ambiguity is not something that I would think the township would want to jump at.
Absolutely.
So it was more of just a clarification, because that language was in the lease that we got at the last special meeting, but it has since been removed, so.
Well, this, on page 3 of the lease.
The lease or the option?
The lease.
Okay.
Section 3.1 sub B does refer to battery facilities, and it integrates the reference to battery facilities collectively with energy storage facility and also known as improvement. So it's kind of a catch-all, but they do reference batteries.
Yes, I did see that and highlighted, but even in this, my note, my sticky note, still indicates that it isn't necessarily just BESS, but that it could be BESS.
Well, we did take out, because this is, as you might imagine, these things tend to get like form documents, and they capture other text from other versions they use. And so part of what I had to go through repeatedly with the lawyers to strip out references to solar and wind energy, and we did all that, and he took all that out. So my takeaway is that they're not anticipating any kind of, if you're concerned about solar or wind, that's not, it's going.
I wouldn't say I'm concerned about a specific entity. All I'm concerned about is we're not actually committing even to a battery energy. Either way, we're really not, it doesn't look like in this document committing to any specific type of energy storage. We're just permitting it, unless you guys have interpreted it differently.
I interpreted these battery facilities.
I mean, in your mind, it makes sense that it would be battery because that's what has been discussed over
I interpreted
here.
it that way, but it could just be in my mind, because I'm so used to talking about it.
Right, but like in reading through it, there actually was nothing that I read that indicated specifically that this would be battery energy. So I guess I was more concerned that what are we committing to? EJ, I know that this, you're not the one who grabs this language, so you're like, I don't know.
There's no other, there's not anything else that it could be.
Yeah.
Like there's no, you know what I mean? Like it's battery energy storage system. Battery has
Unless something changes. Well, and that's my concern.
There's not though. That's the thing. There's not. There's not. And the only technology that's coming in the future is kind of all the technology you guys have been asking for, which is like the law. The better technology, yeah. And those are still like 5 to 10 years. They're in the testing phase now. So like, even if something different came down the road, it's still always going to be a battery. Battery's just, it's a storage, it's a battery. It's always going to be a battery.
Could be because it's their first battery storage system that they've done too. Maybe the language just isn't in there.
Yeah, it was before though, that was the weird part. That was just what made, it was a little bit of a red
I
flag
think it's
that.
important to get everything in black and white with you guys.
Yeah. So more just a question.
I like that. That's a good catch.
when you're committing to something that could be in the future, that you don't even know what it is.
Right, and
If
this
you
is
don't
a
have
40-year
specific word in it,
lease. Which
it might
also
be
we
worse
did
than
talk
this.
about last time, possibility of decreasing that was not an option, Will? Or was-
The battery
We
was
kind of
was
talked
on.
about
We did talk about it.
maybe going at like 10-year increments instead of starting with 40. But,
I think it was the amount of money they were gonna invest is why they wouldn't do it.
well, Vesper will be gone within 10 years, so.
They'll sell it to somebody else.
Well, did you have a comment on the length of the lease? Did you talk to Alan about that? Wasn't it because of their
About
investment?
20 years?
Yeah. Wasn't it because of the amount of the investment? Is why they wanted that amount of
No, we never
time?
talked about the 40 years, that never came up as a topic, because I didn't know that was an issue. I mean, that's kind of standard, I think, I mean, most ground leases, but, I mean, that was something I never addressed with them.
What else you got to?
Oh, I actually don't even know if anyone can answer this at all, but I did think it was something to consider. Well, actually, a couple things. So, first of all, I am not in the mindset of putting profits over people. So this is not my number one concern. I want that to be very clear. But with the removal of this renewable piece, we had talked in the past about there were grants out there for renewable energy. Could this negatively impact us in any way? I assume not, because again, if it is a battery, if it is, then there would have that renewable portion, but could that negatively impact us? Yeah, like if we're grant money, if we wanted to.
I really can't answer that, to be honest.
Yeah, I didn't know if anybody could. Like I said, I had noticed that it was removed everywhere and didn't know. Speaking of money, this was something else that I noticed in the lease. The lease portion does not actually commit them to leasing the entire property. So we have tossed around some figures of 4,000, 5,000 per acre. However, they have the choice in this lease to not actually lease that whole thing. So really the numbers that we've been projecting may not be as accurate if they decided maybe they only need 10 acres or 15. In the other site, I think it was somewhere around there, right?
Yes.
So we could be potentially cutting our projections in half.
A third.
A third,
Mm-hmm.
right?
If they only, so you're
Where
saying
did
they,
you see that?
they could
I just
lease,
found it.
I remember the language said that they could go to the nearest quarter of an acre.
Well, it starts right on page 1 of the lease. Actually, it starts on page 1 of the option, and then it's page 1 of the lease, and then it's throughout the lease, but it does say the land consisting of approximately blank acres, because that is to be filled in when they determine how much they'd like to lease. Including without limitation, easements, right of way, blah, 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 blah. And then, hold on, let me find the sticky note. Okay, so, oh no, that's a switch yard. I would have to find it, but it does start there, and Will, I'm sure you can attest to this, you've looked at it a million times.
Yeah, that's not how I interpret it.
Okay.
My interpretation is, they reference the property as the leased premises. And the leased premises is referenced as exhibit number 1. And exhibit 1 is the description of the entire parcel. Now, they haven't plugged in the specific acres, because frankly, they've been using 40, which we want that, because I think it's less than that. I think it's 37.2 acres. But if they're gonna say 40, that just means we get more rent. So I'm happy with calling it 40, and so they're leasing the entire 40 acres. Now, they may not, and I'm sure will not, build on the entire 40, they're gonna probably build on about 10 acres of that. And there's gonna be another 10 acres that they're gonna commit to what they call switchyard property and buy it from you guys and sell it, transfer title to utility. I think that's how this works. But that's, I think, sometime in the future. But the lease premise is subject to all the rent for the entire term, 40 years, is 40 acres. 37 acres.
So they just didn't fill that in the lease as a number?
Well, it's in the basic terms and conditions, they've got it with an asterisk, because they're not positive on specific acres. They're roughly referring to it as 40, which is good, because it's, I don't think it is 40, I think it's 37.2. But they're prepared to call it 40.
Okay.
Well, I think that it's 40 plus there's a little tiny corner across the street that's actually part of that originally, I guess before Bridge Hall Road went in. I think that's how they come up with 40.
Well,
There's probably no use to it.
Well, that's interesting, Bob, because like today or yesterday, they mentioned in some email I saw that they're interested in the northern portion of the property, and so that's on the north side of Rachel, and I wasn't aware that.
I don't know what you could do with it, it's a little tiny triangle.
Right, yeah, I mean, I know that the township owns property up there, but I didn't know what that meant, the
That must be
northern
it.
portion of the parcel.
Where's that, where Warden Road comes out by?
I have to look at the map, but when you do, there's a little tiny, Daniel, I'll probably find it. There's a little tiny triangle on the north side of Range Hall Road that's actually part of it. That's why I think you have 37.2 and then that little piece. But I'm just being, I don't think you can do anything with it.
Right.
I see.
Ain't there another pit that's obsolete, not being used, they could go to?
We don't have a pit that's not functioning right now, and you have to be on the ITC line. I mean, that's kind of a narrow down in the properties.
I'm sorry, I'm just gonna reorient back to the option.
Yep.
So this, and help me to understand this well. So the option, okay, property. Property is the land more particularly described in Exhibit A, consisting of approximately 40 acres, okay? So then, moving forward to the next page, owner grants the grantee, so this is under number 2, an exclusive right and option which may be exercised at any time to lease the property or any portion thereof. So that, I guess, is maybe where I received that, misunderstanding, or I just, I mean, I think it's a big difference if part of the reason that there's any movement on this is because we're talking about numbers and figures, well, those might dwindle quickly. Again, I am not saying that that is the reason that this decision should be made is financially, but I do think that it is something to take into consideration as we make whatever decision we make.
Sure.
So, did you think that, is
Yeah,
that?
no, I see exactly what you're saying, and it is ambiguous. They do refer in the option to the Exhibit B in the option, and the Exhibit B is the ground lease. So now we go to the ground lease, and the ground lease talks about Exhibit 1, and Exhibit 1 is the entire parcel. So you kind of daisy chain it. I don't think that they've ever, in my review and all the discussions that we've had with these guys, I've never heard any indication that they're considering leasing any portion. But I agree with you. I mean, that's a phrase that if they're considering only leasing 20 acres and reducing their rent.
Cause really, you'd only need about, what, 14, AJ? Is that?
12 to 14.
12 to 14.
Plus your switch yard.
Plus the switch yard, yeah. So
Yes,
that-
well, that's separate and
Yeah,
that's
that's
the
separate,
purchase.
yeah.
So the lease really still would be probably 12 to 14 for the actual battery.
Yeah, typically what we do is we lease all of the land, and then usually it's like a private landowner.
Yeah.
And we would just give them the land back to use while we're still leasing them.
Okay.
So, like, I'm not a lawyer, so I can't read that, but from all my other projects, we would lease the entire land. We build within that, we build in the setbacks, all those things.
Sure.
So, while we might only need 12 or 14 acres, we'll probably need 2 to 3 times that just to make sure the design fits the WIO you guys come up with in the future as well.
Okay.
And so, you know, with that, the setbacks, if they're gonna construct a project and site it and be compatible with whether it's a WIO or something that the state comes up with for the ordinance, they can't do anything smaller than what the setbacks require, they need all that. But if they're considering, and I think it's less likely in this property than it would be on the other property with all the land, to try to lease less, you know, like to save some money on rent. I mean, is that, I mean, it's a legitimate inquiry, but I've never heard them talk about, but that's something we can consider.
Okay. Shoot, I just had a question and I lost it. Oh, I was hoping you could, and Teresa kind of mentioned this. Will, you might be able to answer this. EJ, I don't know if you'll be able to or not. I understand that we have Vesper Energy Development, we have Vesper Energy Finance, and we have Woodson Energy. And we have all of them listed here. So we have the address for everything being Vesper Energy Development. And then we have like this financial branch, probably for your
Investing in
investors.
Yeah.
And then we have Woodson Energy, but the lease being with Woodson Energy and not Vesper Energy. I guess if somebody could kind of just explain to me that.
So the reason
picture.
why it's tied to Woodson is so it's really to ease all the concerns that you have. Is if we were to sell the project or if anything were to go to that project, everything we agree to is legally bind to that Woodson project. So if someone were to buy the project from us, they're bound to all the contracts that we've signed with you, with whatever Woodson LLC is signed. If that makes sense. We just have so many projects, 49 development across the country. They can't all be Vesper Energy LLC because then it'd be like Vesper Energy LLC 1, 2, 3, 4, 5. If that makes sense, because they're all different businesses. One parent company, but all the projects are different businesses. If that makes sense.
So when whatever hits the fan, doesn't have any money to back it up?
No. And that was gonna be my next question.
Yes.
Yes. Because that was explained to me, if they did, trigger the option on the lease and commence the lease. At that point, Woodson Energy Storage LLC would be, would borrow a lot of money. And all the bonding and all the investment would flow to Woodson Energy LLC, which would then purchase all the equipment, man up all the energy consultants and contractors and everything that it took to put a project online. Woodson would be infused with capital, investment capital at that time. Right now, they're just a shell company and would remain so unless and until the option is exercised. Once it's exercised, then all the money from the investors flows into Woodson and they become a valuable entity running this thing.
I know we had talked about the WIO language being in this, Will. And I see that we have some language somewhere. It was the same as in the last lease. I don't think that had really been changed. And it sounds like they are still willing to, work toward a WIO, but as our attorney, what part of this discussion, and Keith said it himself, is to have a little bit more control over it. What, right now, control do we have over what they do?
Well, we don't have an ordinance.
Correct.
And so if this was to be approved, then we would negotiate with them just like we did last time, in the spirit of making an agreement where both sides choose to negotiate terms between themselves rather than resorting to the MPSC and whatever the state would determine was appropriate, however long that took. And think it's fair to say that Vesper doesn't choose to negotiate with state regulators because they find it
Right.
challenging. So I think we would probably find a compatible negotiating partner for this property like we did last time. But there's no
So
question.
nothing's really shifting.
No, except the terms are gonna be very different, obviously, setbacks being the biggest one. I'd have to go back.
They wouldn't
and-
have as large of setbacks.
Exactly, right, which is a big thing. But I think all the safety issues, I don't know that, I don't see why that would change. So,
And this, so page 12, this is essentially their commitment to working with us toward a while. Parties agree that during the term, they will continue to negotiate and work together in good faith to agree on language related to a working incompatible ordinance.
are you on the,
This may be the option.
It's the option.
That's the option.
Right at the very bottom there,
Yeah, yeah, yeah.
16.18, sorry.
yeah. Yeah, right, and they put that in following up on the last concerns the board had last time.
I think you had it in there actually.
Yeah,
No,
it
I
was
don't
in there.
think this was here before you guys made some comments and they put that in there. I mean, we talked about it and this is a newer term than.
It was in there.
It was in there. I think we were hoping that there would be something a little bit stronger.
Yep.
Yeah, you had it in there.
Well, okay, but I don't think that was in the very first version. I mean,
Well,
we've
This
gone
was
through a lot of
the,
versions.
this was the version that was like right before we showed up for the meeting.
Okay,
Yeah, it might have been
But I-
the very first.
Yeah, it might not have been in your first one, but this is one that, you know what, it may have been a discussion you guys had that day. So it was added, like right before the meeting or something.
Right, but
I
it was
just-
in the meeting on August 4th, because we pointed that out as being a very weak statement, and we wanted that strengthened. I didn't mean to hijack you, were you gonna say something else about that?
Just to make a comment, the whole idea of signing this lease with you is that we would be going through the local permitting process.
Right.
So we wouldn't want to go into this agreement with you and
Right.
then not abide by the standards that you all set.
Which I would assume
So-
would be at both locations,
Yeah,
right?
yeah, exactly. Yeah, and you know, obviously the only thing is we'll have to change it based on the geographics, but we want to work with you guys and we want to make sure that, you know, you feel as comfortable as possible. So if we can do it, you know, just like the last site, that, you know, we'll do that as well on this one. That's the whole point of moving this, because, you know, I just want to be clear, we can just go through the state on our other site. Like, there's literally nothing stopping us from doing that, but we don't want to do that because we've been here for 2 years telling you we want to work with you, so.
But we've caught you in so many lies.
You haven't, though.
That proved-
That's the thing.
That I proved and published. And
Yeah.
So how can we trust what you say?
No. Jim, did you have anything?
No, I have one question, Will, regarding paragraph 13 of the option. Let me double check, make sure I'm right on that.
Insurance?
Yeah, I wanted to see if it's important to you that we receive notice of cancellation. It's in the lease, but it's not in the option.
well, obviously, nothing is gonna happen on site, for the option, is they're gonna do some general feasibility work.
I defer to you. I just noticed an irregularity and just wanted to bring it up.
I'm sure they wouldn't have a problem with providing language in there that they would confirm coverage when asked the investor question.
Yeah,
Yeah, oh yeah, for sure.
okay. That was my only comment.
Just because he had just brought up insurance, will that, recommendation from our insurance company, that's a little foreign to me still, that, adding the waiver of subrogation. Remember that?
Yeah, I didn't see that, I mean, I saw that reference in the email, but I didn't see that context, of, I haven't seen that policy or how that topic came to be, but I certainly agree with the principle of that being included. So it's pretty typical.
Okay, well, I mean, I guess I just didn't know if that, like, would that be an appropriate place or in the location Jim was referencing?
Well, again, I don't know what your agent brought up and responding to what question. I didn't see the dialogue that resulted in.
There
this.
really wasn't, he looked at the insurance from Vesper,
Okay.
which I suppose could look different. I don't know who's gonna be the holder of insurance when upon this, but, really honestly, after looking at theirs, that was just his comment. They should be adding a waiver of subrogation to auto and liability and have Groveland named as a certificate holder with the address listed underneath. I am not someone in insurance. If anyone is here and you know what I'm talking about, fantastic, but that was what his recommendation was.
Well, this language does say that the policy shall name owner as an additional insured, so that's covered. That's
Okay,
already in
so we
there.
got one piece anyway.
Yeah.
Okay,
So as far as the waiver of subrogation, that's not in here, but, I can't imagine that they would have a problem with that.
okay. I don't understand the legalities of that, so I just wanted to make sure if it needed to go in.
Okay.
Does anybody else know what that means?
Absolutely not.
Okay, great, let's know, we're on the same page.
It just sounds like maybe the cost is gonna go up.
Yeah, right. In insurance language?
Yeah, just a keyword there. Increase in price. I don't put your nose down yet.
That's all right,
I was gonna take a break.
Yeah, I appreciate that, so I can work. I think probably just the only other thing, Will, and it's in here, if you could kind of just give us a picture of what this looks like. You guys have indicated in the past that this will probably not be owned by Vesper for long. It probably will be sold. And it does look like, it appears that, you know, all of this is attached to any owner down the road. But how do we make sure some of this stuff doesn't get lost?
You mean, an assignee of, like, so if they trigger the option and they decide to lease the property and commence operations, and Woodson Energy gets infused with money.
Yep.
And runs the project for 10 years. And they can assign it to another entity that has the capability of running it, and that's language that's preserved in the lease, so.
So that's all right,
So that's a good
we
thing.
reference in here.
Similarly, if any mortgagee, right, lender, decides that there's a default on any of the loan obligations at Woodson or whoever's paying the money owed on the loan to the lenders is in default and a mortgagee comes in, God forbid, there's provisions in the lease that addresses what the mortgagee with the bank can do or not do. And so we spent a lot of time on that. And I'm convinced that we, as I said at the beginning of this meeting, that we pushed them as far as they're gonna go. Because past that, a lot of language is just mandated by these banks. And it's very bank friendly. You know, the lessee and the mortgagee, if it has to come to that, needs to have the rights to come in and control this project and deal with the collateral and you know, if they need to take it over, but no bank wants to do that. So if it came to that, they would probably shut it down and pull off some of the assets, or they'd get another operator in there that could run it effectively. I mean, those are worst case scenarios. And any assignee, mortgagee that came in would be bound by the terms and conditions that are in this lease. So they'd have to pay the CBA, Community Benefits Agreement, they'd have to pay the rent, they'd have to cover any expenses that the lessee would have. So it would step into the shoes of Woodson, if Woodson for whatever reason, can't or won't function as the lessee anymore.
I can't agree with that because in the thumb, Minden Township, with all the windmills, since they started those, they've turned over 7 or 8 times, and it's a mess up there. They lost paperwork, things got set aside, and the new owner says, we didn't know we had to abide by this, and it's a mess. I know people up there going through it right now.
I don't remember seeing that in here. Is there any type of clause that they are required to inform us upon any transfer immediately?
Oh, yeah, that's in here.
Okay.
Okay, so if really, Woodson Energy and any other company that purchases from Woodson Energy is legally bound by what's in this lease, I don't recall seeing things in here about annually, training all the local fire departments and making sure that, you know, they have hazmat equipment and suits and whatever it is they need, because one of these things catches fire, you can't go out there and breathe that stuff. And I didn't see that in here about the, you know, the annual training of fire departments. And I think that's important, and I also think it's important to put in here, independent monitoring, on a regular basis, specifically, like I thought we talked about that last month, that we wanted to see something in here about, you know, instead of just allowing Vesper or Woodson to monitor themselves, we wanted to have some additional monitoring requirements, independent companies going out there and looking at it maybe, you know, monthly or semi-monthly or whatever it is, so that, you know, we've got what's the word I'm thinking of, impartial third party who can take a look at it and, you know, report back to us. I mean, if we're still the landlords, we have a right to make sure that our property is, you know, being used in a way that is in keeping with our expectations, and if they're not spelled out specifically here, you know, I guess I thought that we had talked about that a month ago and we were gonna put that in here.
That was the WIO piece. So, this actually just, hold on, let me think. So if we have a WIO in place, if we work toward a WIO, they commit to a WIO, that allows the permitting. So we still have that ordinance in place. But,
I was just say, from my experience, the WIO is where you would make these rules and set that language for us, and that would be the basis of a denial for a permit
correct.
or anything like that.
But when that property is transferred, no one is going to try to get approved anymore. They have already been permitted, and that is not.
We're still, whoever would buy, if say we sold it, they're still bound to the permit, to the rules of your permit. So whatever rules you set up in that ordinance, no matter who is on that land operating, they have to abide by those rules, or else you come in and you hit us legally with, you know, fines, whatever it may be.
So we would have to have a permit that indicates ordinance 16-4 from the year 2025.
It would be.
Yes, don't you know?
Yeah.
I think Will might know.
He's right, so ordinances are the laws of the township.
Right.
So whoever is on your land, operating consistent with your lease, still has to comply with the laws of the community. And if WIO has provisions that require training or require certain standards of inspection, maybe monitoring, and that's in the ordinance, then whoever is acting under the lease, whether it's Woodson or any S&E, would still be bound by the laws of the township. And I also think that, you know, the
But it actually, I'm sorry to interrupt you, Will, but just, cause I'm struggling with this because I'm trying to wrap my brain around it. Cause it is a workable, incompatible ordinance. It is an ordinance that really does not actually match state law.
Mhm.
So really, if they shifted, but can you see where I'm struggling here? Because technically they could change a lot of things and still be abiding by the state requirements.
Well, I mean, certain state laws, nobody can detour from, and we wouldn't try. But with the workable incompatible ordinance, it's incompatible with the provisions of 233. So, for example, the setbacks and some other safety components that are not required by state law, but if the township, the municipality can reach an agreement with the developer, right, that would be acting under the WIO, then it's sort of like a contract between the township and municipality and the developer exercising rights under 233. And if they can't agree to the language of the workable incompatible ordinance, they're gonna throw their hands up and go to the state.
How long are these batteries good for?
10, 15 years.
24 years.
How many?
They're warranted for 20 years.
20 years?
Protect them 20 to 40 years as a project, just as they degrade, we upgrade them.
So like in 20 years when that battery's, I'm just thinking through here, guys.
Yep.
Let's say 20 years, that's done and gone. That battery's gone, they've removed it, there's somebody new in there. Maybe state law is real easy now and they just go, yep, I wanna do something different. At that point, we have nothing as long as it is an energy storage facility and they're
Well, I
under
don't
our
think they
lease
can-
terms.
I don't think they can cherry pick the law. I think once we reach a WIO and that is, then under the ordinance, the lease gets energized and they go online, right, with their, what they call it, COD, the commencement of operation date. And the licensure that is issued by the state is based on the WIO that the township has. They can't then, with a change in operators, decide, well, we're not gonna recognize that WIO that was passed and this property is required to be complied with. We're gonna now see if we can't get a better deal with the state. They can't. Once they've committed to the WIO process and the township has passed an ordinance in furtherance of that, they've signed up on that. Now, the interesting thing is what happens is, we're talking about what happens if 233 goes away. You know, the township, you will have created an ordinance and a lease, right? So you've got the law of the township and you've got a contract with the developer that now has the right to do
For 40
what
years.
what you wanna, you know, what you agreed to have it form. But now, without the force of 233 behind it, that's a gamble. Right?
I think those were most of my big things. You got a lot more sticky notes, you sure? I had another thing about grant money, but I don't even know, that's on page 5. But I already kind of mentioned grant money, that just kind of sounded like the language was assuming that we were not able to receive grant money.
Can I ask a question? Is there a meeting scheduled with Barry to come to agreements on his current list? Because I feel like all of this discussion is mute until you get an agreement with Barry.
That would be between Vesper and Barry.
Well, I actually disagree with that.
I disagree with that entirely.
We own the lease with Barry.
Yes,
It's not Vesper.
No, we do, but I'm saying it would be up to Barry and Vesper to work something out.
No,
If they
we're
wanted to
asking
come.
us and Barry to either cancel the current lease or agree to not cancel the current lease. It's one or the other.
Well, not necessarily. Barry could go in 7 years, 8 years, whatever, and be done in there and say, all right, I'm done, I'm walking away.
It's still the current lease.
Which is
means
his.
you can't agree to a new lease until that lease is terminated. Whether it's 3 years from now or in 2028 or 2025. I think you said 2035 was the date.
Will, you wanna answer him?
Yeah, so
So has a meeting been scheduled with Barry to discuss his current lease and determination?
Barry doesn't have a lease. Barry has a mining agreement. And
Okay.
it's a contract between the township and Barry to mine property.
It's
that
still
the
an
township
agreement.
owns.
It's still an agreement.
Well, it's an agreement.
Okay.
There's no question about that.
So
And
that
he
is-
absolutely has lawful rights that the township will not abrogate. But Barry's in control of what he wants to do with it. Barry may decide that he's,
I understand that. Is there a meeting scheduled between the township and Barry to come to that agreement?
well, I don't know that there needs to be an agreement with Barry necessarily, as the supervisor said. Vesper knows that Barry has a right to mine until 2035. And if Vesper and Barry can come to an agreement, and Barry tells the township, I'm prepared to modify my agreement with you. I'm satisfied, I can make it work on terms that I agree to. I approve, I've negotiated with Vesper and the township, I'm prepared to modify my agreement with you. That's up to him. But, so it's not the township that at this point is.
But if Barry can't mine it based on Vesper's agreements, then what's to stop him from suing the township for not standing by our mining agreement with him?
This agreement is specifically conditioned, it's subject to Barry Bass. So whatever, well.
So when is that agreement gonna be decided?
Well, that's really, I'm not aware that Vesper has discussed anything with Barry and Barry has made a decision. It really isn't up to the township to tell Barry and Vesper what, how Barry can use the property. Well, we know how Barry can use the property. He can mine it consistent with the agreement. It's how Vesper can potentially work around that, and I don't know that the township's been involved in those discussions yet.
No.
So what is the advantage to Vesper for even entering into this agreement? If you have to work around Barry Bass's agreement with us, like why
Well,
would
with the
Vesper
Senate.
even want to do this?
It's a guarantee.
Because we were told that this land was more compatible with what the community wanted.
Bob tried to get you guys to move to one of these properties last year.
Okay.
And
So Justin's firm was involved in talks, I don't know, maybe December of this year. And that question came up about moving the spot. And we explained to them that MISO, we have a queue position where we're stuck at that certain spot. Senator, can't think of his last name. Yes. Said that he had spoken to MISO and that there was potentially a way for us to be able to move our spot without jeopardizing our queue position. So with that in mind.
When was that?
When was what?
When did Mr. Danaskis speak to, when did, you said it was last December? Or?
It was earlier this year, January maybe, when we were in town. The last time Jessica, Henry, and myself came into town and essentially said, we don't approve of the site where you're at. There's this site over here. Why can't you build it here? We explained to them, we're kind of bound by the queue position to be in this place. If we were to try to move our site, we could potentially lose our queue position and we can't build our project. I guess he had a conversation with somebody at MISO, and it was, I don't know if he did something or if someone did something, but we were suddenly allowed to move this site by, I think now the deadline is September 19th, I believe, is we have to have a new lease with the site name and everything like that. So the reason why we're doing that is because we were told that that's a potential way for us to still work with you and go through a local permitting route versus going the state route. Essentially, we were told we won't be approved, there won't be a while that approves us on the other site, and that our only option would be to go through the state route. So we're here now because, as I've said multiple times, we want to work with you guys to build this project. So that's the benefit, is we get to build this project. It's good business. I know people don't think companies do that, but that's literally the reality of it. We can went to the state 6 months ago. We went to the state November 30th of last year.
But you didn't.
But we didn't, yes. And this whole time, I've been trying and communicating with your township to work with you to come to an agreement to do it locally, so we're not shoving it down your throat.
The whole time since last November.
Yes.
Who have you been communicating with?
Your supervisor, with Jim, with Will, with Justin. We have weekly meetings.
So the reason you guys prefer to move over here and do this agreement with us is so that we will basically give you permission to start this project, and we will help you with the permitting and
No.
pave the way for you to
No,
do this.
it's that we were told that if we decide to stay on the other project, state permitting route is the path that we have to take. And we have that option to do that tomorrow. You know what I mean? So that's not gone away.
Right.
But we were told that if we look at this site, this is a more realistic way for us to come to an agreement locally through the permitting route. So that's why we're here. If this falls through, I'll just be candid. We'll have to go through the other site and do our due diligence through the state. We don't want to do that. We want to work with you guys. We want to do all the stuff we said we want to do.
So, I have a question. So the reason that we were given in the meeting initially last year when we came in, we talked about moving it to the gravel pit, and I have it unrecorded, your voice. We cannot move it because of cost, injection sites, the power company won't do this. You gave us a long list of reasons as to why you looked into it and couldn't do none. So
Okay.
you're giving, that's a lie.
How's
So
it all?
again,
I just told you that Senator Dukakis
I know.
spoke to MISO, and that was our number one
I know,
holdup
but you
to
gave
move the
us
project.
you gave us a reason in the meeting. It wasn't because we already have this specific address. It was because of this long laundry list of reasons that you spit out. in
I guess I'm confused as what I lied about. If you can tell me exactly what I lied about,
So you told
I'd
us
like
that
to
you
address that.
couldn't move the site.
Because
of
you were in a
injection.
queue position in MISO,
No, that was
which
not
I just
mentioned.
explained
That was not mentioned,
was
sir.
fixed.
It wasn't mentioned.
Okay. Well, I don't know what, I mean, I don't know. I don't know what to say to this individual. So.
And recorded.
And just so you know, moving this site does cost us more money. Everything that we're doing is costing us more money. We would save money by going through the state, save time, save a lot of, of this, going through the state. So, I might be, I might like to get beat up or something, but we're here because we truly want to do this. And, I've had multiple conversations with your staff about this. I don't think we've ever once been dishonest or lied to any of you about anything. I'd love to know if we have. We're trying to be as transparent as possible in this process. Carrie?
I just have one question, and actually it is for Vesper, two questions. The first question is, have you actually submitted a full site of what this is? Not just the generic about 12 acres or 15 acres or possibly up to 20 years, but do you have in writing a full site yet? You were asked for one by Bob DePalma when he was still the supervisor.
A full, do you mean like a design, like a full design?
A full design, yes.
We can only, well, now we're gonna have to do a completely new design.
Did you ever do one?
Now, we're gonna have to do a completely new design. On the prior one, I believe we had up to a 10% design. You can only design these out to as far as you have your studies done. So we can't do a full 100% design if we don't have all of our studies completed.
So to answer my question, can you say yes or no? Did you ever submit a full site plan to this board?
No.
Thank you. My other question is publicly, can you tell us when your company, whichever site you choose, when do you, as a company, plan to build by?
I believe we have a construction date end of 2027 is what we're anticipating.
2027?
Mhm.
Okay, because on your website it says 2029, which means that the Barry Bass question has to get accelerated if this is gonna go there. That's why I
2029 is
asked.
our, I believe, our operations date, 2027, I believe, is our construction date, when we would start building.
So we have an agreement that gives Barry enough, in my opinion, enough time to actually mine out what he has paid for and has an agreement to take out. And he believes he has 10 years in which to do this, and the price of gravel and sand keeps going up, so therefore he's got a lot of money wrapped up in that site, and we are entertaining the idea of moving something that in 2 years, potentially, basically kick him off the site, or severely limit his ability to take
Barry
material.
would have to agree to that, you guys aren't necessarily.
I understand that Barry would have to agree to
And
that.
I just wanna explain, like, you know,
but-
we work with people that have these types of deals all over the country, and, you know, he's in a business, so he probably is in it to make money. So I'm sure that there's something that's gonna happen over these next few years
Yeah,
in
and-
discussions where he comes to a place where he feels that he's satisfied with what he has, and we feel that we're satisfied, and we move forward.
So potentially what could happen though is, he has banked a lot of money with us, and if he hasn't taken out an amount of material that would equate to the amount of money he's given us, we will have to refund him money.
Would you have to refund him money, or would the person causing him to not take that material?
Well, that's not in the lease. That's not in here
I think
anywhere
that's
that I
because this
saw.
is a lease between us.
No,
and-
I
and-
think it may be in his, or in his agreement, isn't
Yeah,
it?
can I,
We owe
I
him.
think as a practical matter, I think what he's getting at is, if Vesper needed to move into the site sooner than later, they would make Barry an offer he couldn't refuse. And he would then release the township from further obligations under the mining agreement.
So, but we still haven't had this conversation with Barry, and we've had months to facilitate a meeting like this with Barry, because all of these questions and concerns came up. It's definitely the elephant in the room from last month when we met. And the fact that it's still not ironed out, to me, just is a really big red flag. It really is, and it.
When I talk to Barry, Barry's very simple. Justin, you can back me up on this. Barry says, tell me what you wanna do. That's Barry's mentality.
Barry told me he would need, he couldn't say exactly how long it would take because he doesn't know the quantity of material that's out there. That he would, need to have a study done that would help him understand the quantity of the material, and, I just don't understand why we would take what we have as 10 years of an agreement with him and force him to meet a timeline for something, and also enter into an arrangement in which we are basically granting permission to allow this battery energy facility on a piece of property that is open to the biggest, cleanest, largest, most active aquifer in the state, the Marshall Formation. That's it. When it's polluted, it's polluted. And I don't feel, I would urge you not to bring this to our township property because of that resource that it is ours to protect or neglect. The choice is ours.
Has anyone tested to see if it's already polluted? I hate to say it, it's 2005, everything's polluted. Has anyone tested it to see if it's already polluted?
Do you drink the water out of your well?
Oh, absolutely, I have, I well tested.
Yeah, then it's probably not polluted. 'Cause that's the water that's under all this stuff, right? I drink the water out of my
I don't know where
well.
my water comes from, I don't know.
You have another comment over here.
I'm sorry. Yes, ma'am.
Hi, I wanted to know, why was this site selected in the first place due to the aquifer and the clean water? Why was that even
I can
mean,
take,
clean water is a basic.
I'll be able to take the blame for most of this. When I was elected, they talked about putting this in a neighborhood. And just in my own mind, and part of it would be fitting in with our zoning, was to get this thing in a gravel pit and out of the middle of the woods, was my idea. So I can take the blame for that. I would rather.
It doesn't make sense to do that.
It is a neighborhood though.
Yeah.
Yeah, it
Destroying
is
our
to some
water.
extent.
We're all here, and I think we all feel that this should not go through, and we don't want it.
Yeah, and the water is important, and, I mean, we all need it to survive. That's what we have, and I'm fairly new to Groveland.
Sure.
I moved in the COVID era, and I remember the Groveland Voice Facebook page. Someone started a, what do you love about Groveland? And if anyone remembers that, everyone said the green spaces, the trees, the space. We're not a city. We're a small town. We like it like that. No light pollution, none of that. I mean, that was just a few years ago.
And I'll be honest, I mean, we've got three choices in my opinion. You do this lease, or you don't do the lease, and you work with them on a while on the other piece of property, or you say no and they go to the state and do what they want. I mean, to me, that's the three options we have. Go ahead, Pat.
I'd asked before, but there wasn't really an answer to it. Let's just, God forbid it would happen, but let's say that they contaminate the aquifer. My property isn't worth a bad battery at that stage. So who's gonna pay the piper? Who's going to, I'm left with a piece of property with no water, while I sell it with a case of bottled water? That's not happening. What is the contingency?
And unfortunately, I think we're all in that same boat.
Yeah,
honestly.
well, that's why I'm saying, okay, so we're in that boat, that's that road.
Right.
Who is going to get us water?
I
Who's
have
gonna
no
replace
idea.
our wells?
I have no idea.
That won't fly. I mean, no sentient person, even at the state, the politicians, I mean, they can't expect that. And if people haven't approached them with that, then we're definitely at fault.
Go ahead.
I have a really simple question. Okay, we're all fighting this right now. If they go to the state, are we just all screwed? I mean, so it's, I think.
How do we know that? Well, I mean, if they go to the state, I mean, we could go up and fight them.
Yeah.
I'll just be honest with you, Will, you could probably elaborate on this more. It's, NPSC, everybody thinks is this big public service. It's 3 people that are appointed by the governor.
Yes.
So when you wanna talk about a weighted game, it's a weighted game. Matter of fact, she just put somebody on a couple months ago that was actually basically her energy czar before she was appointed to this council. So I think it's naive to think that we're gonna go up there, or anybody, not just us, that they're gonna shoot you down. They passed this legislation to get this stuff in place. And to be honest with you, they probably did a disservice. These companies would probably have better luck if they hadn't even had this thing. You know, if you took a project like this, how long would it take to actually do this? 2-3 years to go through the township, maybe?
10 months.
Yeah. But all the waiting for these people, the government really did us all a disservice in a lot of ways. Go ahead, sir.
How far do they have to be away from both small and large natural gas lines? Since we've got a fair amount of those running around here.
You know, I'm not sure on that. I mean, it would be, in your setbacks by the state, I think it's 50 feet from the road right away.
Yeah, but Enbridge has some pretty big names.
Oh, yeah.
Yeah, I would want a lot more than 50 feet.
Yeah, that would be state regulated on distances from something like that.
I think one thing for people to know that are new to this, because I've been immersed in this for over a year now, I would highly recommend that you start looking up what happened at the most recent Best Fire in California. You will learn that the damage that this environmentally, that this smoke creates, if you think it's limited to that gravel pit, you're sadly mistaken. That traveled for 10 miles or more. Evacuations happen for miles. So it's not gonna just it's gonna pollute my backyard, whether it's on Tucker Road or whether it's in there, and it's gonna pollute us no matter what, we're screwed. So it's not an isolated contamination, they destroy all the land.
Go ahead, sir.
I just wanna go back to the comment I made earlier in regards, you're talking about the legal battle for this and all that. How much money did this township spend, well, I don't know, 30, 40 years ago to stop Staples from coming in? All based on the concept that what they were gonna put into that site was gonna go into the groundwater. That's what they based the entire legal fight on, and won that.
We didn't actually win that,
Well, they stopped.
It was a technicality that was.
That is not what they wanted, though. What they wanted, well, do you want to elaborate on that?
Yes, it was a private company that was trying to do a landfill, but they didn't have the benefit of the state legislation to do what they wanted to do. It was very different than what we got here. So Staplex, they had problems with their methodology, with their siting, and so, the township just successfully convinced the circuit judge that their efforts to use the land that they had an interest in, was, not enforceable. But they didn't have what Vesper has. The power of the state legislature saying you can do what you're planning on doing in this community. Very different.
No, I still think you should fight it to the nth degree. Look, I've lived in this town for 50 years now. And, you say it's not a residential area, it is. I mean, and it's not becoming residential anymore because we're dealing with a festival now, we're dealing with this thing going in now and all the industrial area that's going in over there, and everybody else gets to deal with the rest of it being rural, and we're stuck fighting it in our own backyards. So I think the money should be spent there to fight it just like it is.
I sure do. Not to beat a dead horse here. On page 9 of the lease, 13.3, and maybe this doesn't matter. I know that the mining agreement has been mentioned in many other places, but this says no reserved uses by lessor from and after the effective date. So I'm gonna pause here just momentarily. So EJ has just indicated most likely they would like to break ground, if you will, by the end of 27-ish, right? All right, so I'm guessing that this option, they'll take the next, if we agree, most likely would probably hit the ground running and doing some testing on the land pretty quickly.
That's what these two folks
That's
are
what
here
these
for,
are-
is
these
from the
folks are
PEA
here.
group, they're already starting to get that process going.
Okay, so that would move pretty quickly, which would probably lead into an effective date, probably within this 2-year frame. Let's just say it's about 2 years out from that
In our head, we
2027.
would see maybe like a Q1 permit application, assuming you would pass a YO before the end of the year. So like maybe January
Of 27?
of 26.
26.
January, February, March of 26, apply for a permit. And then we would, after we were permitted, is when we would move forward to hiring our EPC contractors and folks of
Okay.
that nature.
So that would be the lease, when you would.
The lease would be executed then, I believe.
At that.
I don't know,
That's-
Will, is it executed on permit? It can't, there's language of when it would be executed.
Sure. That's okay, we can come back to this anyway. I wanted to kind of just get us into that picture of a timeline. After the effective date, I assume whenever that they've agreed to leasing instead of the option.
That would be the start of the lease.
Yes, that's what I'm saying. That's what I expect this would be
Which
when.
is different from the start of the operation. So the lease starts in, let's say, 2027. It may not be until 2028 when they go live.
Well, no, that's what, but they would have had to lease it
Yeah.
to start breaking ground.
To start doing their due diligence, to get things ready, to install all the storage facilities and hook up the lines to the utilities. That's gonna take some time.
So the lease would already have been in effect.
Yes.
Correct.
Mhm.
So we're anticipating it would be by the end of 27, at the very latest, that this lease would be in effect.
Assuming nothing would hinder
assuming
us from
nothing
moving
prevents
forward,
you
yeah.
from moving forward. So, essentially, Groveland Township acknowledges and agrees that neither the lessor nor any of the lessor's lessees or grantees. Now, I know that.
Other than Vesper.
Right, other than Vesper. Now, Barry is not a lessee, but that language is not in this one. And it does say that they would be the only one to have any rights to use the surface of the leased premises until the termination of this agreement. So this is the only place that I really saw that the mining agreement was not indicated. I know that it's kind of covered in there, but this does specify the effective date, meaning like saying, don't touch the land anymore.
You're absolutely right, that says what it says. However, this lease is also completely conditioned on the mining agreement, on Barry's primary rights under the agreement with the township to do what he's entitled to do under that agreement. Vesper takes subject to Barry's rights throughout everything, until and unless Barry might negotiate something different. And I think that probably is gonna take the form of a really big check from Vesper to Barry, would be my guess. In which case Barry takes the contract with the township and tears it up. That's what I think would happen.
So then, basically, the checks that Barry keeps writing us, those go away. No more checks from Barry every month, $7,700 a month, no longer.
Well, is that, but he was mining throughout the, and so where those royalty payments are coming from, I'm not sure that would necessarily terminate. I mean, he was gonna recover back $1 million thereabouts the township owed him from mining his property.
But what I'm saying is, once that happens and Barry's no longer, because he got paid off by Vesper, we're losing $92,000 a year from Barry for income, and we're gaining, whatever Vesper's paying, or whatever Woodson Energy is paying for the lease for the land that they are occupying.
Correct.
Well, you raise a really interesting question, and I'm not prepared to analyze the royalties that Barry is paying now and basis for that, and how long the terms of those payments are going to last, compared against his rights under the mining agreement. I would need to sort all that out. I mean, I'm just looking at his interests in this mining agreement on this property and what that means for Barry. And then ultimately Vesper, if the township agrees to this lease, to this option and the potential lease, how Vesper is gonna navigate that, because it's gonna have to. I mean, this is an elephant in the room for Vesper, but they evidently think they've got a plan, and that's between Vesper and Barry. Because the township is not gonna break the agreement with Barry Dennis. Barry will tell us if he wants to modify it, because he's satisfied that he's otherwise, recovered the consideration he anticipated from getting through that mining agreement. But you raise a good point about, is that tied to the royalties that the township's otherwise receiving now? I don't know the answer to that.
So they could buy off Barry could basically just say, okay guys, that's it, but we have this agreement with him till 2035.
He pays $7,700 for that parcel, this 37-acre parcel, or everything?
He pays $7,700 a month for royalties for mining.
For everything that he mines?
Wherever he mines. I don't know where he mines, but that's one of the places he could mine.
I just wanted to point out, the community benefit agreement that you would get if we built this project on this site is, it's $10 million, so it's $250,000 annually. So we're talking over $20,000 a month. I think you'd be in a better place afterwards with us based on the community benefit agreements and everything. So I understand the $7,700 a month going away, but we'd replace that $7,700 with the lease terms plus that community benefit agreement would be attached. Now that wouldn't be until operations, so it wouldn't be in that, that 1 or 2 year period where we're building, but you would have that.
just give one last comment? You know, you talk about the loss of income and all that, so are you guys gonna count on the loss of income when, you know, when you reduce our taxes based on, you know, our property values going down from this going in our area? I don't bet you our taxes aren't gonna.
You know, here's the thing, the assessors make the determination about property values, and I'm guessing that the state is probably the state, and I'm a victim of the high taxable values myself, right? And even though I've been here 28 years, I can't believe my house taxes are as high as they are, but, I don't think the state's gonna say, oh no, your property's worth nothing now because of this. Like, all those people by Moss Landing, I don't know what their property values, but that's California, and that's a whole different ballpark, right? But are their property values decreased because of that catastrophe? We would think so, but I don't know, you know,
Yeah,
and.
but there's certainly, they're quick to raise them.
Right,
And
I
then something
mean,
like
maybe
this gets
nobody
thrown
would
in
wanna
there,
buy
yeah.
them, but I
You
don't know that
they'll
they
bring it
lowered
back
their
down.
taxes, right? Yeah.
You're saying that the state, that we can't fight the state, there's pointless and everything, but where has, do you have examples of where the state has come in and forced this down, township store? How many of those have happened? And where?
I don't have.
So it may not have happened, so that could just be big boogeyman that's being thrown there.
I know people have filed or started to file, but I don't know if they've pushed them through yet.
Okay, so it hasn't yet happened, that the state has forced it on someone.
As far as I know.
Okay, so we do still have a chance.
There's only a couple that have actually even just recently filed, so this is all in. So they haven't had like a stack of applications since you wanted to go through. A lot of people are just laying down and taking it. They're not fighting back.
Anything else? Oh, I'm sorry.
That's okay. What Christine said about air pollution, we have been under, polluted air effect from Canada's wildfires, way up in Canada, all over us, in Oakland County, if you've been watching.
Yeah.
The other thing is I wanna bring up and go back to, if Vesper sells their interest in us to another company, and there has been a WIO agreement, and you're saying, well, that'll transfer. What about when you buy a brand new car, and you have a warranty, and the warranty does not transfer to a new owner, unless in that warranty it says that it will transfer to the new owner. And I believe this might be an equitable type of situation where there would have to be some kind of wording that secures the fact that if they bow out, our WIO is still in effect with a new entity.
We had kind of talked about, that was the language we had talked about, actually stating, committing to a WIO, not working toward agreeable language. Because right now, this does say they would, again, saying this understanding, you guys have, you know, said you've been very cooperative, but at some point you could change your mind. And this current lease doesn't commit them to a WIO, it commits to talking about a WIO.
Yeah.
And I'm sure that's challenging to figure out a way to put it in there, but I think that's just kind of what she's indicating. There's not actually a commitment to a WIO in the lease.
Right, well, and I think it'd be pretty much impossible to get them to, I mean, if you're suggesting sections of the lease that would outline what would otherwise become the workable incompatible ordinance and have that in the lease, I can tell you the lawyer would say no, because all a lease is just an agreement between the landowner and another entity to use your land. And, but that is still subject to the laws of the land, right? And so that's a WIO for that particular described area is reached with, that's for Woodson. That stays for that property. Whoever is the assignee or transferee or mortgagee or whoever operates for the next 40 years. So you don't need to have it in the lease. I mean, the language in the lease that says we're going to work towards a negotiated good faith WIO, that's good. And I'm sure that they mean it. But I can't imagine agreeing to language in a lease that would basically say, well, we're gonna put the laws of the land in this lease, rather than, we're, as a part of the licensure approval process, they've got to comply with the YO payment, through the township, through Lansing, for their license. And so they'll be signing off on.
They don't have to comply with it.
No, they don't, you're right, they say, well,
I think that's what she's indicating, is that there's
Well,
nothing.
I just wanna point out, we wouldn't sign this lease, we wouldn't sign this lease and then just not sign a local WILE with you, because what would be the point of doing this lease then? We can just go to the state on the other property that we already have.
Or you could go to the state on this property if you felt.
But we don't want this property. You guys wanted us to have this property. This isn't the property we want. We don't know what, we know that the other property is ready and good to go. Like, we still have a lot of due diligence that we need to do on this property and everything like that. So it doesn't benefit us to move to this. I just wanna explain that, like, this hinders
That's why I couldn't
everything we're
figure out
doing.
Why you would want.
It's because, as I said, we wanna work locally with you
And
guys.
it's a 40-year commitment.
As a 40-year
Here.
commitment with us helping them get permits.
You guys wouldn't help us get any permits because we would have to, abide by all the rules that you set. You're the one that is gonna dictate whether I get a permit or not anybody else. That's the whole point of this lease, is so that you set the rules and not somebody else. So I just wanna make that really clear. If we sign this lease and we move locally with you, you get to tell us, this is what we want, this is what we want, this is what we want. If we don't, we go to the state, we just have to abide by what they've said. I'm not saying, so, I understand everybody's worried, but it would not make any sense from a business perspective for us to sign this other property and then waste all this time and then just go to the state anyway.
So, if you sell your part in it to another company, you said that you would keep it for maybe 2 years, possibly that could happen, and then your entity would be sold to someone else. How does the WIO fit into that for this new people?
So, the WIO is just a set of rules that we have to abide by to be awarded a permit to build our project. So once we apply for that permit, these folks up here will dictate whether all of our designs and specs fit in with the rules they've set up. And then we're now bound by that building permit, their special use permit. Wedge and Storage is bound by that special use permit, no matter what. We're not like any other business, guys. If you build a grocery store and they break your zoning laws and they have unhealthy stuff, people come in and shut you down. We're just like any other business, and it's the same exact standards. We have to play by all the rules. And for us, I would think, I know a lot of people worry because there's a lot of money involved in this. I think that should give you a little bit more security because there's so much money involved in this. Nobody is over here just we're gonna just do this and gonna do that. You have multiple people way smarter than me looking at everything 10 times before anyone makes a decision. So.
My question is, if it transfers from you to another company, are they bound by what you're saying?
Yes.
You're gonna go by all these rules and
Yes.
things that we've set up.
So the
So
permit,
are
by
they
definition, is an
bound by the
ordinance.
same
It's a law.
thing?
yeah, it's a law. The WIO is a law. It's just like the state law. So once they pass it, it becomes law. And then we agree to that law. Our permit is tied to those rules. So if we break, if whoever we sell the company, they are also abide by everybody is. So all the community benefit agreements, good neighbor agreements, anything that we sign and commit to, the next company has to. Think of all the companies that have bought bankrupt companies in the past. They acquire all their bad debt. Now they're responsible for everything. They gotta pay it. It's the same exact thing. We would have to, whoever would acquire us takes on all of our obligations. And the reason they would do that is because they're gonna get all of our money too.
So that is an assumption, even though there's not wording in the
No, that's
lease.
the law. That's the state law. That's a law that lists in every business right
The
now.
WIO by definition is our local ordinance. It's an ordinance, it's our
Okay, so it
version
is
of the
a
law.
law that anybody has to buy by.
Right.
All right, that was all question.
Carrie, go ahead.
Which brings me to what I was gonna ask. So the WIO's been sitting since prior to last November, and after the planning commission passed it, which they passed it now with everything that the public and the residents asked it to be passed on, by the way. There were certain things that were in there, and I did hear it tonight, making sure that there's an independent contractor that's going to inspect, Oscar Larson would inspect, gas pumps to make sure they're operational, cause they don't wanna blow up. This is worse than a blow up of a gas station, guys. If it were to happen, nobody has a crystal ball, I get it. But so my question becomes to the WIO versus the lease. So first, if I understand it right, let me get all the way through, please, is that you guys are offering from the township to Vesper an option to lease. They will then say yes or no to that. Then if they have that option to lease and they decide to lease and build on there, which it looks like they're going to, and I'm just putting this all through my brain listening tonight, then Vesper, whomever, will get all this money poured into the Woodson storage to allow them to then purchase materials and hire people. And I looked at your website again, and it's really good reading. You all should go to Woodson Energy Storage and look at their website. There's some things you said on the website, though, EJ, that you said to me personally that it kind of conflicts and it doesn't match. And I'd like to talk to you about that on record after. The other thing, though, is that, or here tonight, it doesn't matter. But the other thing that I don't understand legally, and I've been looking into this since the last special meeting we had about 2 weeks ago. And this is why I'm recommending co-counsel, and for you guys, independently. Somebody to step in this picture, and the only way I can think to do this is if I'm gonna buy a Ford, and I sign all the documents and I end up with a Chrysler, that ain't how it works. I'm taking home the car that I want to go to buy, and I have to abide by everything that is in that document before I sign it. I mean, I've gone with our adult children, they've done all the work themselves, I go look over that contract, and I make sure. Before we bought our property, we looked at that contract. Before we signed with our builder, we looked at that contract. And frankly, I'm gonna tell you a little personal. They said finished upstairs in there and had a price next to it. Do you know what we got? Georgia Quality Carpet had to do the carpet because it wasn't finished. We didn't even get a bar in the closet. Did they even put up the insulation? Regardless, my point is, you can put something in a contract that says finished upstairs, or something that is in this lease right now, that doesn't, if you don't have it in the lease, because I'm concerned about what you said, Will, that later on we'll get a WIO. This board, I think, needs to decide if they're gonna take that WIO as is and vote on it or not. And frankly, we went 100% on the WIO the way that it stood with the planning commission. You didn't have a unanimous vote. If you look at what the planning commission did, Danielle's the only one in the room that I'm aware of that was there for sure besides us. And you guys can go back and watch it, but it was not a unanimous vote, and it doesn't have everything in it. So if you stick to that WIO, we're not gonna be happy with the WIO the way it exists still. Because we were thinking we were gonna come and talk to you guys about making some amendments to the WIO, not talking about some land lease. But so now, I think it gets murky. And EJ doesn't know, the same as I don't know, 100% how murky this gets. But the last time I was here a couple weeks ago, I just looked up something and I said it was only on AI and on a quick search. But if you got a lease, that is what binds this township. And then you got all the mess with Barry Bass too, that you're saying let them iron it out with on the sidelines somehow or another. That's up to you guys there, I'm just saying. But if you go to try to put a WIO in after the fact, and right now if what I'm hearing right, you're saying, we're gonna abide by the WIO after the fact, once you put it in even after the lease. Now I don't like AI because it's not accurate, so I'm not going by AI. So I started to do some investigating on my own. I don't have the full answer yet, but just like I've given you guys everything that I find before, like just for the people new to the party, your insurance company will know exactly what this is, will not. If you have to shelter in place or you have to evacuate and you have any wildlife or anything else that dies, you can't even buy coverage. I tried. Because I anticipated this coming. And I tried to get insurance. You can't. If you find it, please let me know. So no, your costs are not gonna go down, your taxes are not gonna go down. Everything for us will go up. And if there is an event, we're gonna be screwed. But the reality of it is, if this comes, then the amount of what needs to be in this lease and slash WIO needs to be made clear. And we need to know that it's what it is. That's what I'm here saying tonight. Is that if you guys, and it might not even be unanimous if you were to put it to a vote. But, and I appreciate this due diligence. Let me just say this. You guys are here all these hours, you're putting in all this work, and we're only doing it on the sidelines. I do appreciate the work you're putting in. I do appreciate the upfrontness. And I'm recording just because it's getting late and I'm gonna go back and listen to all of this later. And when I do, what I find in the law portions of it, because I have done on some of the Michigan.org sites in the last 2 weeks, just so that I can compare. Because I want us protected. Like I said when I started tonight, I care too much. That's what I've come to realize, but I won't get emotional anymore. I'm losing my voice because I was in the Arizona dust storm last week. But I do care. I care that we're doing it the right way. Everybody is doing it the right way. Yeah. You might not be able to do a while later.
Okay, if I talk real quick.
Oh, I'm sorry.
I'll make it quick.
Go back.
So, EJ, I'm glad to see you here, actually, I am. Because for you know, some input over that from Woodson and Vesper. Unfortunately, I'm kind of a big business kind of mentality person. And I can see where, like Will said, I mean, if you go to Barry and say, look, dude, here's a big check for you, Barry's gonna sublease or do a sub, whatever he does, do a contract or whatever. I see that, but I guess the question is whether or not Whitson's just gonna say, the Vesper's gonna just say, look, we're just going to state, we're tired of this messing around for 2 years now, blah, 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 and we're just gonna go to state, and you guys are gonna have to deal with the ramifications at the local level. And that's what I'm afraid is gonna end up happening, because they, spend a lot of money for plane tickets and studies and hotel rooms and meals and more studies and everything else. So eventually they're gonna either wash their hands. How close is Vesper to washing their hands of this project up here?
I mean, I had to ask to continue these conversations with you locally because my leadership team wants to take the other route. So I think we can do this locally. I know I'm not saying everyone's going to be happy about it, but I think it's much better alternative than the state route because I'm going to get everything done that I need to get done, but I'm not going to feel good about it, to be honest with you. I want to give you guys the community benefit agreement money. I want to do the grant programs and stuff. And
so the Vesper is going to either keep pursuing. Is that what I'm hearing?
Oh, we're going to build our project. If we can't build it on this parcel, we will move forward. We've invested a lot of money already up to this point. We have a key position. We will move forward on the other site if that's necessary. It's not what we want to do.
So the fourth option that I see, Kevin, is for us to keep fighting and going to the state level and trying our best to convince the 3 board members that, look, this isn't the good thing for our community.
Thank you, Greg.
Bottom line.
Go ahead.
For those that think consumers' energy is gonna raise our rates, they are completely unrelated. And if you research the last few years, their financial statements, you'd never want stock in that company. They're horrible. I don't wanna be near the best, but we need dozens of them in this state. I trust them more than consumers. Read about consumers.
Do you want me to share some info about them?
I'm aware.
You got anything else?
I'm saying lesser of 2 evils, in my opinion.
We don't benefit by these, by the way, guys. We don't benefit by these. They take the storage and sell it to the highest.
I
bidder.
agree.
Okay, just to make sure you know, this doesn't help
No, I
everybody.
do.
How do you guys feel?
Don't want everybody to be missing.
That's what we're here for.
Jim, you've been very quiet.
Just taking everything in, listening to people, weighing what I hear with what I think. I would comment if I have anything. I don't have anything right now.
What do you think?
I'll tell you what I think, and my job is to lead this board, and I understand that to some extent, but I would never force this board into trying to do something that you're not comfortable with. So I'm leaving that up to you guys. If you wanna vote on it tonight, we'll vote on it. If you saying you wanna table it, you can, it's your guys' board.
Janelle, if you were asking me, then I do want to say something to the audience. If I understand all of this correctly, and I hope I do, so Will, Justin, comment if I'm off base. We have before us the opportunity to sign this option. I think the option is in the best interest of the township in light of a number of unsavory conditions. We've all been laid out on the table. If EJ's group runs out of patience with this for a variety of reasons, for either their own decision criteria or running out of time with the state, then we default to the site, the first site, Site A, I think Bob referred to it. We have little or no control over that, depending on again, if EJ's team says, hey, you guys, we still want to work with you on a while, I'm sorry this didn't work out. It is the lesser of a bunch of evils. It does sacrifice for, I would believe, more homeowners, the converse, I'm sorry. By moving to the site, fewer homeowners are affected. It's a new group. I heard very loud and clear what Teresa said about the aquifer. I can only comment that my opinion, that's all it is the existing site, Site A, is likely on the same aquifer, just not immediately available to the surface water.
Correct.
How far that pollution, God forbid that event should ever happen, goes, the least amount that I've been able to find from research is that it's likely gonna burn into the aquifer if it's a major event. So that's not quite a wash, and it's certainly not a moot point, but the weight of that, only in my mind, is ancillary to this. So where I'm heading with this, let me comment on the Barry Bass thing. We have asked Barry on numerous occasions, on numerous initiatives, say, hey Barry, can you do this? This is all on Barry. We can't force him to do a thing. We can say, listen, we might like you to do it for the following reasons, which I just said. But that's up to Barry. It's not part of any agreement other than Barry and Vesper. He can cancel this for, hell, if he's got a fly in his eye and has a bad day, he can cancel it. So my opinion to the board and to my community friends out here is we probably should move forward and execute this option. Tabling it just forces EJ's group's hand to move forward in a way that's not very beneficial to us. So if that's what you're asking me, that's what I'm saying to everybody. That I would, that's my opinion for us to banter back and forth. Comments?
Keith?
That's, honestly, Jim, that's what I wrote at noon today. It was basically what you just said. We can either voluntarily enter into this agreement and have a say in the terms, have a say in the process, or they can go the other. There's four pathways to getting a permit. We can have a CREO, which is a compatible renewable energy ordinance, which is 100% in agreement with the state, with the guidelines, the 21 guidelines that they set out. We could have an incompatible ordinance, and we could still try to get something done. We can have a workable ordinance, try to get something done. That is a workable ordinance. Sorry, the YO is a workable ordinance, and an incompatible one, they would just go to the state. The other option is just to go to the state. There's four different ways you can go. And one of them we have a say in.
Yeah.
Two of them, we have a say.
Well, only one, because the CREO is exactly what the state says. The YO, we can add language to.
Yes, but the YO could be on the township's property, or the YO could be on property that they already have. We have a YO that was just never brought to the board for approval. Don't know if that
But the
is
Y-
even an option anymore,
The
but.
WIO, in the adverse relationship, the WIO can't be any more stringent than what the state says.
Unless Vesper
If
agrees to
it's
it.
voluntary, but as I
Yeah.
say, if it goes the other way, and they wanna go around us to the state, it means nothing.
But they already agreed to.
Technically, they can in this too, Keith, that's what we were talking
They've
about.
already agreed to it, but we haven't signed anything.
Correct. So there's a WIO that exists that has not been brought to the board for approval yet for the other piece of property. And I believe that, you know, it was not brought on purpose because we were waiting to see what was gonna happen with the lawsuit, which now we've been waiting as long as we've been waiting, and it sounds like we're only a couple of months away from, you know, some sort of a decision, and we're having this, like, gotta
But
do it,
again,
gotta
that
do it.
lawsuit doesn't take away 233.
I understand
It addresses
that.
some of the process complaints that people have.
Right, but I think there's a lot of pent up, I do think statewide, there's a lot of pent up anger towards, the legislators for putting this stuff into, law, and, you know, there's an empty seat that Gretchen Whitmer purposely didn't fill, and when she finally does let it, you know, come to a vote, I mean, 6 months from now, 8 months from now, it could look different. It could look way different because the composition of the legislature.
That won't matter, they'll make a decision in the next 30 days.
Okay, I understand that. So their decision is, do we go here with their cooperation, or do we go back to the other site? And if they go back to the other site, then they still have to decide, are we gonna go through the state, or are we gonna ask the township to pass the WIO? And
Well, yeah, I guess
Right.
you're right. in
And the
that.
WIO is still lead for
So,
that.
again, we're
But
talking about.
they don't need us to pass the WIO.
no, they
don't
don't,
need
but
us here.
they don't need us to pass the WIO anywhere. They can go back to the other place and still do whatever they want to, right? And again, I mean, like, you heard him, this complicates things for them to do this. And
I just want to remind, we do have a deadline of September 19th to move this site. So like that's, you know, I know it does feel like it's kind of rushed, and it's just kind of because we just found out about, you know, all these deadlines the last couple of months when you guys did, so.
It's, September 30th.
Did it get moved? December 19th was the last time that I was, they've moved it back a couple times, so.
To muddy the water and ask a stupid hypothetical question. If you went back to the other property, would you still be asking us for a while, or are you going right to the state?
You gonna pass this a little while? I mean, I was told
I'm
that.
just asking.
The reason we're here is because I was told the other property's not an option for a local path. So that's why we're here, because local path is the way we wanna go. Like, I can't be any more, there's like no nefarious scheme here. We wanna permit this locally, and that's the only reason we're signing this lease. It's the reason why we've been having these conversations for the months we have. We've increased the money compensation for the community benefit agreements based on these. So like, I'm genuinely sitting here saying, like, I understand it's your job to ask all of the questions and everything, but like,
No, I'm just asking you that question so everybody knows.
Yeah, we want to do it on this land so that you'll allow us to permit locally. If we're not allowed to do that, then yes, and you don't let us permit on the other land as well, we would permit through the state, because that's our only option that we would have. So if you're more comfortable with us moving it here, and the community's more comfortable moving it to the gravel pit, like, that's what we'll do. And I told Kevin that, I said, I will move it to wherever we can physically build it, and it, like, you know, on our end, that we can make it work, and where you folks think it's best, and that's the site that we will propose.
You had just said something and I'm not sure what I was going to say. I think, you know, you had mentioned something about the community benefits increasing. I'm sorry, I haven't been a part of all those conversations. Was that even an option at the other location?
So the community benefit agreements are part of assuming that we're gonna be working together.
So that's just something you do wherever you're at, or?
We do it when we work with localities to
Okay.
permit us, but if you're gonna fight, not allow us to build our project, we wouldn't
Right.
reward you for that.
No, that's okay, you had mentioned that, I just wasn't really, I wanted to make
Yeah.
sure I got the whole picture there.
Yeah, so the idea essentially is, this allows us to pass on a lot of the benefits of the project to the
Sure.
community as well. And that's in addition to tax revenue.
Oh, I'm sorry, Carrie.
No, I'm sorry, I just realized earlier I misspoke. I said that Danielle was the only other one, but at the ground level for all of this through the YO and through, the planning commission, Jim Christopher's a trustee, and he's been on since day one and knows probably better than the four of you. So I misspoke, I'm sorry, I just wanted to correct my speaking. And then EJ, can you just confirm one thing for my husband and I? When you were talking with him, you had stated that you helped to write Public Act 233 with the
No.
state of Michigan?
I am a part of the Michigan Industry Energy, it's like MIEBC, and what they do is they send language to industry partners anywhere across the country. And we look at it and we send it back, we say, oh yeah, that looks good, or that looks bad, or that won't work. Same way with that, when we develop a workable ordinance with them, it's the same way. So I didn't write anything, I looked at it, reviewed it. Yeah, it wasn't like I didn't write it.
For my clarification, for on the record, basically the Vesper ordinance had input into.
Everyone in the industry.
Input.
Yeah, like basically like and it's not like, do you think we should, I would've told them no, not to pass that law, because Kevin's right, this wasn't around when we first started. Then they put this law into play after we had already been here for 8-9 months, I think, or 5-6 months or something. And it's made it completely harder, because instantly, I would reject me too if I came in here and like basically feel like you're being told you have to do it. So it's made my life harder. These rules don't exist in other states, and we have a lot easier, route forward.
And one final thing earlier tonight, I believe EJ said for 2 years been coming, I don't know if that was a misspeak of the 2 years, but if it's been 2 years, this neighborhood just began to learn about it in June of last year, and there was a meeting out at the police post, the local police post at Grange Hall and Dixie Highway. So one thing that I would say that I appreciate better now is a little bit more transparency. I would really ask too that, I don't understand why we couldn't have waited for September 8th. I think this room would have been filled if you wouldn't have had a special meeting, because people have the date on their calendar for September 8th. But when it gets posted like yesterday or whatever, a lot of people only found out about it today. It makes it hard to rearrange schedules. So if you guys could do this, if you're gonna, I've heard tabling I heard earlier tonight, Teresa did make a motion to table, and Janelle said she'd second, but with discussion, and then Jim saying, well, maybe we should, with Keith commenting possibly too. One thing that this board needs to do, or this office needs to do, you guys have all of our addresses, because all of our taxes get paid to you all. It is inexcusable that 2 years ago, or even a year ago, that every single resident did not get a notification, and it doesn't count that you had Woodson Energy send out a postcard in the mail. That does not count. People think when they see signs sometimes, and I've had people stop in my driveway and say, what is the best? And they want to know still. I'll be outside in the yard, and they pull in my driveway and want to talk, because they have no clue what it is. It is irresponsible of this board in its past, and especially back in the day, to have not notified these residents. And it needs to change. You guys need to notify every single resident. So you either table it and get your act together for the residents' sake, or else you sign it and you let the residents know what you did, and you see who you have in here once they get your notification.
The only thing I can.
Speaking for others.
The only thing I can tell you, on the 8th, we weren't gonna have a quorum that night. A bunch of us were gone, so we wanted to have a full board.
We can't even have our board meeting on Monday.
That's why we had to move it ahead.
Fair enough. Thank you.
That's good.
This meeting was on the front page of the Citizen.
Well,
Or
we have-
second
we
page
have
of the
the Township.
Citizen.
We don't have the Citizen.
Only important
No,
though,
it's not.
because
It's
someone
not.
sent them, I've never seen a citizen.
Yeah, that's the problem, our paper only
I didn't even know it
does
existed until within the past year.
I just want to make a statement because I've been one of the biggest mouthpieces in these meetings for quite a while. And I'll just say that. The point that where I'm at with this personally right now is that I know these slime balls are gonna get their way. I know who's in the state. Like you said, I know who Whitmer just appointed. I know that there's a push for these stupid data centers and all these things coming from Michigan. This goes way deeper than the stupid battery project. And so they're probably gonna get their way. If I have to pick between having their garbage in my backyard or in a gravel pit, give them the damn gravel pit. That's where I'm at with it right now.
Thank you.
You know what you read on her road, if it's at the other location, huh?
What's your thoughts?
Yeah, it's in my backyard.
Um,
Either way.
I mean, as far as the lease, I think there's a lot of ambiguity in this, and I know that you guys are coming with, you know, sounds like very good intentions, but personally, I mean, we have information on here that doesn't even indicate full acreage. There's no actual commitment to what type of energy storage. And yes, we have talked about battery energy, and I do know that that is what has been submitted to MISO. However, I also know you can make amendments. Like that's the September 30th deadline, is to proceed without making modifications to that plan. So that makes me uncomfortable. I think we know that this is a decision. Every single meeting that we have had about Vesper or BESS has been packed. And it is the responsibility of this board to make sure that if we're signing something, if we're committing to 40 years, not a little 10 years here with the option to renew, we're committing here to 40 years of what the entire community doesn't want. And I just think that every I needs to be dotted and T needs to be crossed, and I'm sorry, but when I look at this lease, I don't see that. Maybe it's better in this position. I am very concerned about that aquifer being exposed. Smaller site location. I think that honestly, in looking at it from when I have looked at the maps, I really don't think it affects any fewer residents either way. It's just a different angle of the map, realistically. If you look at that map and look at who it affects, we also, as far as being from the high school, it's about maybe
3/10 of a mile further.
Yeah, it's really not any further from the high school. You're now located, which I know these are probably a little bit easier to move, but you've got all of our recreation right there. You've got 3 campgrounds.
Yep.
And the,
Oh yeah, right next to the KOA campground.
yes.
Right next to it.
Well, and that's what, but here's the thing, what I'm saying is, well, no, and I totally understand, because you know that I do. It is affecting about the same amount of households. Yes, so there actually are other homes that are, you have a couple of them that are right there, yours included. And it's really the other site, there are quite a few that are about the same distance.
From my backyard to where that thing would be, 'cause I drove by there and I could see very many houses by there.
Yeah, there were,
drive down into it.
there were quite a few, yeah, they're, like I said, they're kind of like different angles. I do know that you are right there. Again, I'm not saying one is better than the other, but I can tell you, I am not comfortable with this
I think it
lease.
should be totally what you're saying, that these, because they're slimers and they'll get away with whatever they can.
Well, I think even if there aren't any ill intentions, ambiguity leads to issues down the road. This is 40 years.
40.
So I just think that this needs to be refined. It needs to be put together, and we have to have these discussions. And truthfully, Jim, that's great, you're on board. Kevin, I'm sure you're on board. But you guys have been privy to a lot more conversations that I have not been a part of. We have not discussed this as a board. 2 times we've discussed it.
Yep.
So, we are at a disadvantage from understanding and big picture because we haven't been a part of all of those conversations. And maybe we could have modified some of these things throughout that process, I don't know. But I do think that this needs to be not what it is now. So that is where I am at, if you are wondering.
No, I wanna know.
And I still have very, very deep concerns about.
Oh, the berry thing too, sorry.
Yeah.
Wait, can I jump on that again?
Sure.
Well, this was what I was going to bring up. I absolutely 100% disagree with saying this is between Barry and Vesper. We committed to Barry first. We have an agreement with him. If anything, maybe we should have a document that says, I, Barry Bass, understand that Groveland Township is going into a lease agreement or potential lease agreement with Vesper Energy. And we probably need that reciprocated document from Vesper saying, or whoever we're gonna use, I don't know which name, identifying, we understand that there is a mining agreement already on this piece of property.
It's in here.
Well, what I'm saying is, they both need to sign it, and acknowledging both parties know Barry gets priority, and it may not be for 10 years that he's finished. Or maybe he'll get a big fat check, I don't know. But I do think as far as us doing due diligence, we have a responsibility to Barry first, and I think it's neglectful for us to just say, you two work it out. I just don't think that that's right. So I am
What
not.
are you guys afraid of about Barry? What's your fear? Like, what are you afraid Barry's gonna do?
I have.
We're gonna pay $1
With,
million.
you mean, like, without
Yeah,
having him
you
here?
guys keep bringing, I'm just curious.
Well,
What are you just don't wanna hurt his feelings?
no.
No, I'm confused, what are you guys?
It is a legal document.
Right.
I don't know if somebody makes Barry mad, could he come back and sue
Does
us?
he have, that's what I'm asking, does he?
I don't know.
You guys know, I haven't seen any of it, so I
Yeah.
don't know, but like.
Yeah, I mean, he has
what
legal
could
rights
he
to
do?
mine that land, and they're trying to, use this land.
Yeah.
They cannot both
But he does have
simultaneously.
the right to say, no, I'm gonna keep mining the land.
He does.
He
So,
does.
He's
He does.
protected there.
But I don't know why we don't already have that ironed out. Like what, this has been, earlier this summer was when, this whole thing got started. Why wasn't that something that could get ironed out already? Why does it have to be a fuzzy spot tonight, at tonight's conversation? Why wasn't that already all figured out? Like, because that would take.
We haven't even figured out the lease yet, so we can't talk terms on buying Barry out of his contract. If we
but-
don't, you know what I mean? Like,
Yes,
so-
but you're talking
And-
buying Barry out of his contract. We wanted something, all I want is something that says from Barry in writing, I am aware that you guys are entering into an agreement, something that would, that Barry can acknowledge, I have been informed, I know that I have this lease or this agreement extension.
Isn't that what he would be acknowledging when he signed? I thought.
Barry's not
isn't that in
signing
the
this.
lease?
He's not
That-
in here at all. He's not
Isn't
on
that
this.
what is in the leases?
He's not in this lease, this is between
No,
Vesper
I know,
and
but
us.
the mining.
The mining agreement is
Yeah,
referenced.
yeah, so that's what.
It's a reference,
Yeah,
but.
that's what covers Barry though, that's his legal.
Does the lease with the township and Barry allow you to sublease?
We don't have a lease with Barry. He has
Oh, I'm
mining
sorry, you're
rights.
right, that's right. So you don't have to. Okay.
So the township owns the land, Barry has a contract to mine the land, you can't take his contract away, it'd be like Vesper going and getting his car and taking it away.
It sounds like Barry's well aware of all this.
We're not taking anything away from him.
Yeah,
It's
Barry
totally
just
his
has an option.
decision.
Barry just has an
I'm
option.
saying, I'm saying you can't do that, you have to have that more than a verbal conversation. If EJ's saying it's in the lease, what page is it on in the lease that says it's covered? That Barry is in agreement to all of this, and what his agreement is, and he'll take the big fat check. That's the question that's at end, because both Janelle and Teresa are saying, I'll tell you what it'll come back to, and Bob DePaula spoke to it. I mean, just go back and listen to the recording what Bob said.
All of that is between Barry and Vesper. It may impact the township. Right now, this is a casual, perhaps more than casual, conversation with Barry. Say, hey Barry, you're gonna be the gatekeeper on this. We've protected, we've even disclosed to Vesper in the lease and the little green stuff here, that hey, somebody's got mineral rights here. This whole thing's contingent on if he wants to play nice in the sandbox, so to speak. So, yeah, so having said that, to Teresa, it really, at this point, my opinion, I'm an attorney, is, Barry, we're gonna enter into this agreement. You're the gatekeeper. Doesn't influence you in any way. If you say, I don't wanna do it, end of discussion, he goes his alternate way, life's go on. There'll be no hard feelings. It's just asking someone, will you alter the agreement for potentially everyone's benefit. And if he walks on it, I'm not gonna think any less of the guy. It's his decision, it's a business decision. And I don't think he's gonna think any less of our board.
Well, and maybe, I mean, there have been discussions that have said, hey, Vesper will probably buy you out and you'll be good to go and peace out and they can start in 2027. Because realistically, you can if Barry wants to buy it.
So it has no place in this agreement, per se, other than an FYI, in my opinion. I'm deferring to Will. That's why it's not there, again, by my opinion.
Well, clearly the mining agreement is front and center in the option. Vesper knows it, we know it, Barry knows it. And just like Jim said, Barry can completely torpedo this option and this lease, depending on how he wants to interpret it as far as the mining agreement. Is it advisable to have an advance agreement whereby Barry recognizes his interests here and when he's going to exercise them? And by doing so, he would release the township from any claims he has through the mining agreement. And anecdotally, I think he's expecting, or the township owes about $1 million that he's going to be recovering through mining. Now, he's going to get that somewhere, somehow, whether it's from mining, whether it's from Vesper, it's up to Barry. So I don't know that that needs to be negotiated and addressed contractually now. Would it be bad? No, it wouldn't be. But to me, that's not it's an essential component to this. Vesper understands that they could lose the opportunity to build this site, township site, depending on what Barry does. They will have, I think, met their requirements of the MISO in the meantime and preserve their place in line, which I know that is important to them. And so my guess is that if Barry undercuts the location on Grangeville, then we're just gonna go back to the other location. But, and the township will no longer have the CBA benefits that it has presently proposed. And who's to say what may be potentially negotiable through Vesper, understanding that it was nothing the township did by terminating the opportunity at the township location and having going back to the location that they probably prefer anyway. So, I mean, I wouldn't get hung up on Barry Bass's interest. He's a very successful businessman. He got that way for a reason. He take care of himself. And I don't see the township being put in a bad position by not understanding what Barry might do with Vesper. Now, having said that, I'm talking to, through the royalty issues, right? I don't have an answer for that. And I don't know what becomes of those royalties if Barry takes the money and leaves. Now, as BJ points out, that's offset by a pretty healthy annual CBA, right?
Years down the line.
Well, I mean, when the project goes operational, which might not be all that far down the line, because they've got 5 years for an option, and they're going to start building right away. I mean, once they start putting money into this project, they're not going to just dilly-dally. I mean, this is, as EJ said, there's millions and millions of dollars involved in these projects. So this is a big deal for the community and for Vesper. But having said that, it's worthwhile to explore and vet fully what Bedrock Express's interests are, because candidly, I don't know. I mean, I put several calls into their lawyer, Barry's lawyer, got nothing back. I don't know.
Well, and it sounds like, Teresa, I didn't mean to cut you off there, Will, but it sounds like he doesn't know either.
Yeah, right. I mean, he's very flexible, as everybody here knows. And he'll do what he needs to do. And I don't see that as being a negative necessarily in the township now, whatever it decides here. And it's up to Vesper to figure out.
Ultimately, if we own the land that this ends up on, we end up with the responsibility of cleanup. Years down the line, you know, I won't be on the board at that time, but I don't want to leave that to a future board to have to deal with. Like I said, why wouldn't we just sell them this property?
Well, the
I go
language
back-
in lease does require the lessee, at the end of the term, to leave the property in a condition that it was when it started the lease, right?
Oh, so they do that?
Yeah, it does say that.
Do these companies actually leave the land
I can't.
the way that they?
We're gonna place a decommissioning bond before we ever start construction that covers the reclamation of the land. So before anything ever breaks ground, that money will be in a bank account controlled by you or whoever. And that was the whole coming back every couple of years she had mentioned, to ensure that we're keeping up with inflation and everything. And that's what you'll write into your WIO. And we'll have to abide by that.
That's not what's in this lease.
Because it's gotta go in your WIO.
Cause in the lease, it says like 25% at a certain time, 50% at another time, like, even though.
Change to 100%.
The uncertainty in that, and you're putting your finger on an important topic, is depending on what Barry decides to do, what he can do on the property with, in respecting or understanding what Vesper can allow, so the two of them are gonna have to figure that out. If he does mine some of it, but not as much as he might, what reclamation is necessary or recommended, right? Because if he mines out a certain amount, and Vesper can utilize the balance of that, does it just stay as is? Because that's how Vesper found the property, right? So we don't know that. We don't know if Barry decides to mine part of it and he leaves, will probably be an increased water source, right? Because he's gonna probably mine into what is now the levee lake. And that's gonna create a larger lake. Does that need to be reclaimed? I mean, I think his mining activity, he'll leave the slope in a safe condition. And is that suitable reclamation? And so, but we don't know the details, because Barry doesn't know what he's gonna use that land for. But, so, to your point about, we need to figure this out with Barry, that's a legitimate point, but right now, I don't know if Barry knows, I don't know if Vesper knows what his interests are,
So Barry could take $1 million payout from Vesper,
and leave the land alone.
but we still owe $1 million because that's what's owed to him?
No, he would, that would be his rights in the mining agreement would at that point go away, right? We would recognize that his interests, I'm just picking $1 million for sake of discussion, that's his potential interest in that mining agreement. And if Vesper and Barry are able to come to an agreement whereby Barry signs off on his interest in the mining agreement for a certain amount of money, then we would be assured that at that point, the township's obligations with Barry under that mining agreement also go away. So we need to do some accounting, reconciliation on the contractual obligations that have evolved between Bedrock Express, Barry's S, various companies, and the township over the years, because, I was talking to Danielle, it's a tangled relationship. Good one, but there's a lot of factors to it. So, we would need to have a closure agreement, an agreement that recognizes that Barry and Vesper are able to come to an agreement on Barry's interests in the mining agreement that the township could, and would require Barry to sign off and release the township for further applications. I'm sure he would do that. But do we have that locked in now? No, we don't.
Right, we don't.
When does the reclamation amount get put in whatever kitty is going?
And how much is it?
Who decides that? Because there is no site plan, as you were saying earlier. So how do you decide how much it's going to cost to clean up if you don't even know what you're going to be cleaning up?
It's to be decided by a third party.
Prior to the site plan?
It will be, the money will be posted, 100% of the money will be posted on or before the COD.
How much?
100% of it, but we don't know what that is yet, because without the full design, there's a third party that will establish what that amount is.
We'll get to a full design point by that time, because we'll be that much farther along, and then they'll know, like, you know, there'll be this many panels, they'll have all the details they need to come to a price.
So before any ground is
It would
broken?
be a third party that we work with, you know, Groveland, we wouldn't hire like our boy to come in and do it. It would be somebody independent that they agree with, they're okay with signing off, and that's how we do it with other townships. I'm sorry.
No, I was just saying before any, no ground is broken.
Yeah, they would, and that's actually a standard that we do in our company. Not every state does that. I think Michigan, I don't even know if Michigan has a decommissioning bond rule, but like, that's a big question that everyone asks us, so we just try to be proactive.
Where does that money come from? How do you, because Woodson doesn't have the money, so you.
Well, so
pay-
once Woodson gets permitted and greenlit, like Will said, we'll get financing for it. We'll go out, someone will say, oh, we have a project that it's got the permission to build, here's the money. And then Woodson will be fully funded, and we'll have all the money to buy everything and pay everybody.
So I think that goes into your very good points about, you know, who the lease is with.
And will that increase over the years because costs?
I mean, I would assume it's some of the idea, and I don't know if you guys work this in or not, is to have that same third party person come back and evaluate it every, I think it's 3 to 5 years, depending on what it is. Oh yeah, today's cost isn't gonna be tomorrow's cost, so it's.
So that even in the event of an upgrade within 180 days, it's gotta be reevaluated and funded.
Yeah, so I think it like ends up, it's the same with like some of our leases and stuff, it's, you know, as the years go on, we recognize that value isn't the same as it was 10 years ago, so we make sure we adjust.
I'll just step in. I mean, I think we could probably talk about this all night. Yeah, don't fall asleep on me yet. We have a great board, and I mean that sincerely. And
Thank you.
I don't feel right putting it to this board, because I can tell you right now, it's probably gonna be a split vote, and I respect everybody's vote, and I mean that sincerely. If there's some things that we think we need to clean up, I know this is not a popular decision with some of the guys sitting in this room, they're probably gonna shoot me. But this board's gotta live together for the next 4 years, and I do not want dissension in this board. I do not want hard feelings. I don't wanna put people in places they don't wanna be. So if we think we can work with Will, obviously, Justin has done a lot of this. If there's some things we can clean up in the next couple weeks to bring it back to the board for a vote, I'm good with that. But I do not wanna put this board in a place that makes it disgruntled.
Kevin, most of the time in our planning commissions and in the board meetings, I would say most of the time we have unanimous decisions. We did not on the Weil, it was 5-2 as I remember. And there's been very few times here that I remember as a trustee. In fact, I think I'm the only one who dissented voted once a while ago regarding the Renaissance Festival's renewal. I'm concerned very much about timing. My opinion, in my industry, everybody, this is not unfamiliar to me, leases and such. So I have a different comfort level. I'm grossly concerned we're gonna box ourselves into a corner we're gonna find other nitpicking details, my opinion, everybody, that they're not material to this lease. My recommendation is that we move forward on a vote with the lease. The things that are minor, I'm really comfortable since I've been in part of the listening meetings with Will and Vesper's council. I haven't seen any adversarial position, not even a hint of it. Could they be liars? Sure. I don't think so, but it could be. So I don't want to table it right now. I'd like to see if we can get a vote to this. And I'm very respectful of people's trepidation on this board. Sincerely, I am. I think we're gonna box ourselves into a corner. Gentleman over there is gonna say, I love you guys, I'm done. And I don't wanna be put in that position. We're gonna run out of time again. We've been dancing with this for months. Community, unfortunately, has to deal with it. So I'm actually prepared to make a motion that we vote on conditions of the option and the lease. If someone wants to second that.
I would second that.
Okay.
All right. Laura, you wanna do a roll call, please?
Janelle Keller,
No.
Teresa Bells,
No.
Jim Christopher,
Yes.
Keith Wiederhold,
Yes.
Kevin Scramlin.
Yes.
You guys, the only thing you don't have in there is you're independent, and you can't rewrite that on the lease. And I don't know, and I know you say you do leases, and I know he's a lawyer, but the while coming after the fact might get you guys in muddy water, because that lease is binding. It's your legal documents.
Justin, it's your show.
Did we adjourn?
Oh, well, we just moved.
Oh, you guys have to vote on
We just-
firefighter, don't you? Oh.
we just-
Gotcha.
Sorry, I didn't mean to do that. No, you guys aren't done yet, you're voting on the firefighter.
I'd like to start with talking about that. No, I'm kidding. No, so we'll keep it pretty short. I'd like to request a purchase of Life Pack 15 accessories from Springfield Fire. It's they just upgraded their monitors, and we have the option to buy a lot of really good batteries and accessories for our current Life Pack cardiac monitors, which we will be continuing to use for quite a while. Attached is the quote for that. The amount is $2,250. We get 9 batteries with that. Typically, those batteries run $100 a piece. So we'd approve for that fund coming out of the funds from equipment purchase with that account number attached.
I make a motion, we approve the purchase of the new batteries.
I'll second it. Laura, you want a roll call, please?
Sorry. Teresa Bells,
Yes.
Jim Christopher,
Yes.
Keith Wiederhold, Kevin Scramlin,
Yes.
Janelle Keller.
Yep.
All right, moving into personnel, I'd like to request that we hire David Mojica as a fill-in firefighter medic. He currently works full-time at Brandon Fire, is looking to come over here part-time and fill some shifts. I worked with him for a while. He's a good medic, good firefighter. Being an asset to the department.
I'll make a motion that we hire David Mojica for the position of fill-in firefighter medic.
Second.
Okay. Jim Christopher,
Yeah, yes.
Keith Wiederhold,
Yes.
Kevin Scramlin,
Yes.
Janelle Keller,
Yes.
Teresa Bells.
Yes.
Then finally, I'd like to request that we hire 3 cadets. I believe everybody already talked to know about this. And cadets would like that program. Sounds like they're a good group of kids to get into the department. They're your neighbors.
I'll make a motion that we hire the 3 cadets. I'm gonna butcher these names. Oliver Di Lorenzo, Rise Dealer Arizona, Timothy Nutt.
Second that.
Keith Wiederhold,
Yes.
Kevin Scramlin,
Yes.
Janelle Keller,
Yes.
Teresa Bills,
Yes.
Jim Christopher.
Yes.
That's all you got, short and sweet. Thank you. Public comment?
Thank you.
Thanks for being here.
That's for everybody.
Mr. Keener? Any comment?
Well, I have a question.
No.
What did you guys just vote on?
To enter
Very
into an
sucky
option.
thing.
I'm sorry.
Option lease for the property. Option lease for the property on Grange Hall Road.
Between Grange Hall and the original site,
Yeah, yep.
but there's a lot of unknowns regarding Site B, the Grange Hall property.
Yes.
There's a lot of contingencies that are
There's a lot of
completely
moving parts.
unresolved.
A lot of moving parts. A lot of moving parts.
It's no guarantee they're gonna go with it.
Pardon me?
It's no guarantee they're gonna go with it. This allows them to be more due diligence.
Okay.
That's what we talked about with Mr. Bass.
So it's considering Site B as an option.
It is in agreement with them that if they would like to lease it, they can put an energy storage site there.
And in addition, we will not block any of their permitting options. Like, yep, now we're gonna move
No,
forward.
Teresa, it does not say that, honest to God. And I'm
No,
gonna
it
tell you.
really does.
It does.
No, change the word lessee, I'm sorry, I'm pointing. Change the word lessee to homeowner, read it that way. It's giving them the same rights that they would have to apply if this gentleman came. It's no different. It's a complete level playing field. We're not just relinquishing any of our rights to permit whatsoever in this.
It just basically says we won't stand in their way for any of the permits, that we will pretty much.
So here's my skinny on that. If you've ever seen an adversarial lawsuit, I happen to find the language I'm using unconscionable. I think the grossest words to incite pain, so grievous, things like that. That's lawyer speak, that we're not gonna step in their way to stop it. We're not cutting them any slack. If they don't pass building codes, they don't get it till they remedy. There's
Right.
no change in that regard. And I'm adamant about it because I forgot to tell you when you asked the question. It's just language. Will, did you hear what I was saying?
No.
Okay, correct me if I'm wrong. Teresa is concerned that we're bending over.
Yeah, we're holding their, we're taking their hand and going, here, let's help you.
Regarding the building permit. And the language could be, by someone not familiar with it all the time, to infer that. And I'm taking the position we are not cutting them slack. It's the antithesis to a slip and fall attorney using words like egregious and, come on, help me with whatever words they use
Well,
to.
I'm not gonna compare.
Well, regardless, the point I'm trying to make is we're not cutting them any slack. If they don't meet state and municipal codes, they don't get their building.
Yeah, they've got, first they've got to get past Barry, right? And then they've got, and I think they're gonna negotiate in good faith with the Y, because they've already done a lot of it. And we've got setback issues, but we all know. But whatever gets negotiated, they're gonna have to comply with that. And then there's the site plan that they're gonna have to submit, and you're gonna have an opportunity to review and criticize and critique and make sure that they abide by your building requirements. And they've gotta go to the state, and they've gotta get licensed through the state, and they've gotta get the appropriate best and safety issues for install and upgrades and operation. So I think by and large, there's gonna be enough checkpoints for the community to be satisfied that it's a safe operation. The one thing that you've all touched on that I still have concern over is the groundwater. It is.
So our own attorney is saying this.
Yeah, there's no question, but Jim raises a point. I don't know where the aquifer is on the other site, so.
Well, no matter where it is, it's buried underneath enough dirt that stuff has to at least percolate down.
You know,
I
and so
mean, there's
that
no
will be,
perfect solution,
that'll be
but-
part of your site plan, right? And the lining that will be part of the install, we'll be putting a lot of attention to it.
Clay lining and that.
Clay lining, right, so you can control all that.
Well,
Teresa, everybody, this is still, we haven't closed, right?
Nobody's made a
So
motion.
something to consider.
oh, we're still on camera?
Yeah, so
Oh, yeah.
something for everyone to consider. God forbid there's an event, and we've all learned, you don't put water on it. One of the things, and my source of information is, believe it or not, a lot of engineers, because I've done a lot of specialty automotive construction, is, Jim, consider this. What if that event happens in a torrential downpour? So to their points, two things. Is it possible? I don't know. Can there be a canopy put over this? Does that canopy interfere with replacement of parts? I have no idea. Can we engineer some level of containment in this thing? We don't know those answers, but we have plenty of opportunity to go through it with them, and to see what's there. All of these are very, very valid. Believe me, I only put this through because I was concerned about the timing. I'd rather have us dictate what's going on than not the state. So all of these are still valid points that we're just gonna have to work as a team and assume that they're gonna play nicely. We don't want an adversarial position, certainly not in the building process.
I believe that Vesper will play as nicely as they possibly can with us.
Well,
I-
yeah, they're in the perfect position.
Yeah, I do believe that this is exactly what they wanted, because now they get to work with us instead of going to the state.
And they have a 40 years guaranteed
40
placement for their
years.
Yeah.
Yep.
Whether there's
But the
anything
other way,
happens
all
at the
the
state or
community
not.
benefits, all that stuff. Go on.
We'll see.
They go
if-
the other way, right?
We don't need that though, Keith.
Well, we don't need it, but
We don't need it today.
We don't. And the reality is we have an entire tech park, and the whole plan is for that to literally transform the financials of this
And
entire
I
township.
strongly believe it will. It's never been about the money.
That's what I'm
It's
saying.
been jammed down our throat. What's the lesser of all the evils that we can somehow?
So
You had a
there
whole
was a
room of
question
people
asked at
wanting
the
to
very
fight it,
beginning.
and there wasn't even an,
At the very beginning of the meeting, there was a question asked by the guy that said, what would be a deal breaker for you? And immediately my mind went to what would push it across the finish line for you two? Because I know you guys are very opposed to it, and I respect that. And I don't know that there would be anything.
I would, if it wasn't on an open aquifer, to me is, like I said, it's ours to protect or neglect, and I just feel like we just neglected it. And that is, this whole entire area is like,
So that's something that we will work together with them on. That's a big concern, Vesper. What can we do to work together to try to mitigate that risk?
Is there any way to close that aquifer before
It's completely fair.
we'd have to fill in the whole darn thing and bring it up to ground level, up to street level, right? And that's not gonna happen.
Keith, I just feel like there wasn't ever a consideration from this board to fight. People were asking us to fight.
Mhm.
And you're right, maybe the state would have just rolled over and said, sorry, we're doing this anyway. But we don't know that, and very few people have actually even taken this stuff to the state. We didn't try. And I think when every single one of our meetings like this have been filled with people saying, no, 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 we didn't even think about trying. And maybe it still would have happened, but these are the people that vote for us. So no, I probably would have voted no, even if this had changed, because this is not what the people want. And I'm not worried about the very few pennies, and oh, by the way, they still don't have to lease that whole property. The language does say that, all or part of. So even the lease agreement is still compacted potentially. So I just don't know that we did the best service for our residents.
So how do we combat the timing though?
Jim, the September 30th for them is only if you want to make modifications. They can still make modifications after the 30th, and that's why I thought it was so important that we acknowledge this does not say battery energy. they can make modifications to MESO.
I should have been more descriptive.
You're talking about them pushing forward,
Yeah.
right?
So fighting it would take time, and while we're fighting it, it's going to go forward. We have no way to arrest the progress. That's all.
And I'm saying, taking it to the state and fighting it at the state level. We have the same very reasons we're using right now, that Teresa and I have argued, that aquifer is huge. Every single person in this township is on a well. If we don't have water, we don't have water.
No, but do you know how our state works?
And honestly, like I said, they probably, we could go to this fight, and they would have said, okay, we didn't have any skin in the game. Now we do. We're directly attached to this.
As a homeowner, I'm extremely thankful because I have some conglomerate company behind my house.
And I understand that.
You know, like, I
get it.
But just knowing what I follow from the state and knowing how shady they are, and they get called out. There are all kinds of activists. There's EDRA that calls them out, that writes letters that very specifically points out, this is your violation, this is your violation, this is your violation. What are you gonna do about it? Guess what they're gonna do about it?
No,
The same thing with Mer's doing about the seat sheeting stuff.
That's
Not
right.
a damn thing. They do nothing. They don't care.
That's right.
They don't care. So the township would have spent probably, what, $100,000 in legal fees to get told we're getting screwed anyways, then we don't get a YO and we have to get stuck with their list of 21 stupid rules.
Well, and here's the thing,
You know,
not many people have applied. On the other
Yeah.
hand, we don't know. Maybe they would have said, well, okay, they're fighting this. It's
could
what,
have, but just statistically speaking with
well,
what
we don't know. We don't know.
The odds are in their favor.
Respectfully, Christine, it took you a year to
It
come
did.
to this
It
conclusion.
did, 100%.
A year
Right.
ago, you were fighting,
Yeah.
and
Right.
you were a force to be reckoned with.
Yes.
And now, a year later,
Yep,
There's-
absolutely. Things have changed. I've watched other things develop. I watch other projects. I speak with grassroots people. I'm very much involved. I see how things are going. And I can make a better educated decision than when I first walked in here a year ago, only knowing very minimally what I could find, not interacting with people, not knowing how it works, not knowing. So yeah, absolutely so. You're not wrong.
so I feel bad for that lady. I know there's a person who just bought the house that butts up to, the township's property. Just bought it. She's screwed, but,
She's known.
she
At
doesn't
the end
even
of the
know
day,
it.
someone's always gonna get screwed. I mean, I don't wanna be screwed, I don't want her to get screwed, I don't want you to get screwed, I don't want you to get screwed, I don't want anybody to get screwed. But at the end of the day, somebody's always gonna get screwed, and none of us are getting kids first. It's just the way it's gonna go.
I would have been better with this if it had been on the north side of Grange Hall Road, on the property on the north side, behind the Mavis and the fire station. Wouldn't have been near the open
Over
aquifer.
by the cement plant.
Yep, that's exactly where I was like, okay, I could live with it over there, but that's not where it ended up. And
So why did you suggest that? Did you guys work for that, or like?
That was the original recommendation.
that was the
That's where we were
recommendation.
gonna go, but we've got other people looking at that property, that's how they got moved to the south side.
I'll make a motion that we adjourn.
I will second that.
All in favor?
Aye.
Thank you, everybody.